everyone, and congrats to the organizers. The UPSA Law School believes in advancing the academic enterprise through exploring nagging questions and pushing the boundaries of knowledge through conferences and intellectual gatherings like this. Our world needs this.
Yeah, the introductory page you sent me, I can't trace it.
Our world needs this, and the illusions of the abundance of information being equated to knowledge has meant that we live in a world in which many wallow in darkness, in the midst of information being a click and finger away. So having more information doesn't necessarily mean that we have knowledge. Sadly, like many things African, customary law seem to have labored in the fringes of research and academic interest. And this fact can hardly be belabored. The situation demands a reset, and this conference could hardly have been better timed. Our partnership with the Fordham Law School is founded on shared values and vision, namely to bring the boundaries of knowledge on issues that confront our respective worlds and communities. This conference, like many others, therefore, provide a template for new scholarship and concrete interventions in our communities through clinical programs and so on. We gather in unsettling times, particularly for academia, when the benefits of in-person gatherings have been replaced by virtual meetings. Yet, the fertility of our ideas cannot be daunted by the mode of our meeting. And I am very confident that the virtual nature of our meeting will take nothing away from the outcome of our deliberations. I wish you all fruitful deliberations, and thank you.
Thank you very much, Professor Abednego Amate, Vice Chancellor of the University of Professional Studies. Next on our program, I would like to welcome the Dean of Fordham Law School to give his opening remarks, Professor Matthew Diller.
Thank you, John. And let me say, John, it's a pleasure to work with you at Fordham and on this conference. And it's wonderful that, that you have united our institutions. So thank you. And I want to welcome all of you on behalf of Fordham Law School. We are very proud to co-sponsor this two-day conference, Customary Law in a Changing Africa, with the Faculty of Law at the University of Professional Studies, Accra. The conference is the result of a collaboration between two institutes within our respective faculties. Fordham's Leitner Center for International Law and Justice and UPSA's own Center for African Legal Studies. I want to thank UPSA and its Vice Chancellor, Professor Abednego Amate, and the Dean of UPSA, Kofi Abotsi, and all of those speaking and attending and joining us today. And I also want to particularly thank my friend and colleague, Professor Paolo Galizzi at Fordham Law School for bringing this wonderful conference to us and for your leadership in all of our work in Africa. Fordham Law School is one of the leading American law schools carrying out research on African legal issues with partners throughout the continent. Fordham Law has long recognized the importance of the African continent, the vibrancy of its legal systems, and its crucial role in global legal discourse. Fordham has for years promoted academic and student exchanges with its African counterparts and is committed to doing so. For us, the focus on African customary law is not new. The current conference builds on the previous symposium on African customary law revisited that the Leitner Center organized in Botswana in 2009. The conference led to a vibrant discussion among some of the leading scholars on African customary law worldwide and to the publication of a volume by Cambridge University Press. 10 years after that gathering, African customary law is as vibrant as ever. Some could argue that its role has further grown over the course of the past decade. African customary laws live side by side with formal legal systems on the African continent. In fact, customary law, the traditional law indigenous to a region or group, continues to regulate many areas of people's lives. While in some countries, constitutional, statutory, and common law have largely superseded it, several African constitutions now enshrine the right to culture and require courts to apply customary law where applicable. In the field of family relations in particular, customary law retains great authority. And in countless other areas, the persistence of longstanding expectations and social practices informed by customary law gives rise to many problems in enforcing contradictory statutory law. Furthermore, lack of access to formal legal resources often means that as a practical matter, customary law still governs people's everyday lives. The significant role that customary law continues to play requires continuing research and scholarly exchanges to explore the richness and diversity of the various customary legal systems existing throughout the continent. In the next 2 days, leading scholars, judges, traditional leaders from around the African continent and leading universities, both in Europe and in the United States, will examine several aspects of African customary law. I wish you all a productive conference, and I hope your conversations and discussions will shed further light on customary legal systems on the continent, and that lessons from African customary laws can be learned and shared by all of us. I wish you the best in this conference. Take care and be well. Thank you.
Thank you very much, Professor Matthew Diller. And it was a pleasure to learn and then study under you. I look forward to coming back again. Next on our program, we would have the Dean of the UPSA Law School, Dr. Ernest Kofi Abochi, to also give us his introductory remarks.
Thank you very much, John. And thank you for your remarks, Dean Diller and Professor Amate. Judges, distinguished academics, diplomats, policy advocates, and practitioners, ladies and gentlemen. Now, the need to apply law to development has been a defining feature of not only legal academy, but also of development practitioners, policymakers, and all who care about the instrumental use of law as a force of good. We here, therefore, can assume that the issue is one beyond controversy, that law, when harnessed properly, can be used to change the circumstances of society and promote development. From building infrastructure to regulating deviant behavior, law can promote or stagnate development. But without customary law in all these, where does it fit in the grand scheme of things? Is it law at all, or do we merely guarantee it in our statute books and constitutions as a matter of mere convenience? What is its relationship to modern law? And what are the points of tension? Do judges trained with Western eyes even understand customary law and apply its conceptual and philosophical underpinnings the way it ought to be? And is customary law even necessary in a fast-moving world in which things deemed of old are usually despised? These are just a few of the nagging and persistent questions that have plagued customary law for nearly 150 years. Perhaps a convenient way, the current way, is to ignore them, sweep them under the carpet, and let us carry on with our lives. For after all, who is complaining? Legal academia, maybe, and given that they are used to complaining about a lot of things as academics usually do, their cries have often been treated as the byproducts of the usual scholastic nagging or musing. Dig a little deeper, and you will realize that the status quo disenfranchises, from at least the juridical standpoint, a large swathe of Africans who continue to live their lives under customary law. For these people, the discussions of this conference are not academic at all. They are the essence of life itself. Thus, from inheritance or land rights, the African living under customary law feels dislocated and ignored by the states that at least at best treat customary law as a subsidiary legal category. For these people, the legal pluralism regime established under the constitutions of many African countries, including Ghana, is hardly enforced, thereby making them both insular and ostracized in the legal systems of their countries. As earlier mentioned, the lack of trained judges well versed in the application of customary law and the active application of customary law itself creates a major legal problem and therefore makes our practice of legal pluralism in reality a pretension. The current situation is clearly unsustainable and demands a radical and immediate about-turn. Our continuing failure to enforce customary law and therefore cater to the legal needs of our people disenfranchises these people and creates a situation of legal dislocation that needs to be corrected. As the world experiences something of a retreat from globalization, legal culture, like culture in general, will play a pivotal role in the lives of people, and the capacity of states to shape and facilitate these remain crucial. In the case of customary law, however, its functional utility can hardly be underestimated, and it's about time that we move past the orthodox critique of informality and the colonial worries that are usually leveled against customary law. It is time to revisit projects on restatement and codification, perhaps, ascertainment, and I will add judicial socialization and enlightenment. We cannot continue to close our eyes to the fact that on a continent where the average person has no access to a lawyer or lawyer, applicable law is far detached from his daily life. The failure to deal with in the law caused by the non-application of customary law remains a huge problem. The complexities of the problems of the 21st century call for bolder actions to deal with it. The time has come for legal academia, judges, lawyers, development practitioners, and governments to deal with customary law quagmire and deliver a solution to the problems of the many people who simply do not have legal provision. It is on the basis of these that I welcome all of you highly distinguished personalities, whom I'm delighted to also announce that this conference has attracted so many people who have crossed the 1,000 barrier for the number of registrants. I do hope the next 2 days will see us engaging in these complex but rather productive conversation that leads to changes in our various society, and I'm delighted to share company with many of you whom I've known as being pillars in the conversation at hand. Thank you once again and welcome to our deliberations.
Thank you very much, Dean Kofi Abochi. I'd like to remind viewers that this conference is being streamed live on Facebook at facebook.com/UPSA Law, as well as youtube.com/UPSA Law. Now, we are very fortunate, former Chief Justice of the Republic of Ghana, Her Ladyship Justice Georgina Wood, has a message for us, and she has sent that message to my very own colleague, Diana Asunabadapa. So we'll take that now.
All right, thank you very much, John. The Vice Chancellor, UPSA, Dean and faculty members of the Faculty of Law, UPSA, Dean Dilla from Fordham University, distinguished speakers and participants. Good afternoon from Ghana. As John indicated, my name is Diana Asunabadapa. I'm a law lecturer at the Faculty of Law, GIMPA, and permit me to add, an alumna of Fordham University. I gladly join you this afternoon to convey to you the warm wishes of former Chief Justice, Justice Georgina Theodora Wood. As some of you may be aware, Justice Wood is bereaved, having lost her mother last year, December, and is unable to join us at this conference, much as she would have loved to. Justice Wood attaches great importance to this African Customary Law Conference for its apt theme, Customary Law in a Changing Africa, and the tremendous development the deliberations at this conference present to jurisprudence in Africa, noting also that customary law is a known area of interest to Her Ladyship. And so Her Ladyship, Justice Georgina Theodora Wood, asks that I convey her wishes for a successful conference and a warm welcome to our friends joining us from other parts of the world. Justice Wood particularly congratulates her long-standing friend, Dean Abochi, and the staff at UPSA Law, not forgetting another long-standing friend of Justice Wood, Professor Galizi, and other friends from the Leitner Center at the Fordham School of Law. Also, the Center for African Legal Studies at UPSA Law for putting together such immensely helpful conference. And so please, Vice Chancellor, Dean and Faculty of Law, UPSA, distinguished speakers and participants, accept the assurances of the support and compliments of Her Ladyship, Justice Georgina Theodore Wood. I thank you for your kind attention.
Thank you, Dinah, for conveying the message from Chief Justice. Next on our program, we will dive straight into the first panel for the day. The first panel will be on constitutionalism, dispute settlement, and customary law. This panel is going to be moderated by our very own Professor Kwao from the UPSA Law School. Prof. Kwao, we await you.
Thank you, John. As John indicated, the first panel is on constitutionalism, dispute settlement, and customary law. We have 4 speakers, Professor PLO Lumumba and Evans Ogada. Professor Lumumba is the former director of the Kenya Law School, and Evans Ogada is at the University of Nairobi. And then we will have Professor Chuma Himonga from the University of Zambia, the Dean of the School of Law, University of Zambia, Dr. Ekusa Ekato, and Dr. Newman Richards. Dr. Kato is from the University of Derby. Dr. Newman is from the University of Nigeria. And finally, last but not the least, Professor Raymond Atuguba, who is the Dean of Law from the University of Ghana School of Law. So we have come up with some structure. So just a little bit of housekeeping before we dive in. We will go straight into the discussions. After the first, after each presentation, we will hold off questions until all the speakers have presented. And then I will have some questions for the presenters, and then we go on to general questions from other participants. We anticipate that all presentations will take about 1 hour and 20 minutes. So each presenter or each topic, because some presentations, there are 2 presenters for a topic. We anticipate that you will take about 50 minutes, or we would like you to take about 50 minutes to cover the topic. So the first topic by Professor PLO Lumumba and Evans Ogada is on the jurisprudential basis of traditional justice systems in Kenya. Professor Lumumba, as I've indicated, is a former director of the Kenya Law School, and Mr. Evans Ogada is a lecturer at the University of Nairobi. So, honorable presenters, the floor is yours.
Thank you very much, Mr. Moderator. I will not preface our presentation with any formalities, but what I want to say at the very outset is that I'll make a presentation within 5 minutes. Then Evans Ogada will make the presentation in a much more granular way. And if I leave at a certain stage, he will answer all the questions that will be posed to us. I, at the very outset, note that the conference is titled African Customary Law Conference. At the very outset, I want to say that that in itself could be a misnomer. that if one were to examine very seriously, there may be nothing that may be described as African customary law, in the same way that there is nothing called European customary law, in the same way that there is nothing called Asian customary law, and that the use of African customary law is for convenience rather than a correct description of the assemblage of customary laws which may be described as Yoruba or Baganda or Kikuyu or Bemba or Igbo. So when I use the term African customary law, let me be understood to be pigeonholing myself in the chosen topic of the organizers of this conference. And you'll see very deliberately that our presentation is titled Contextual Justice, the Jurisprudential Basis of Traditional Justice Systems as an Enabler of Access to Justice. At the risk of sounding arrogant, we think that our title speaks much more truthfully to what is the subject of a discussion this afternoon and for the next few days. And my presentation, being very broad, starts and proceeds on the basis that today, when we talk about African customary law, with the caveats that I've already put in place, particularly we who are trained in Western jurisprudence, we have a problem because our default thinking is fundamentally Anglophile. If you are trained in English customary law, and that we too, like our colonizers, think that African customary law is an appendage to something that we call modern law. But let us ask ourselves, if we look at the history of the things, particularly those of us who are trained in what we describe as the English customary law, what was it? And what was the purpose when the English came into the continent of Africa with their colonization, civilizing agenda, and hegemonizing agenda? The whole idea was to demonstrate to us that what we did in terms of dispute resolution was not informed by law, qua law, and that African law was therefore not law at all. Whether you are in Ghana or in Zambia or in Kenya or Nigeria, we will be familiar with the reception date, and we will be familiar with how African customary law was described. And we were told that African customary law is only applicable in areas where it is not repugnant to justice and morality. You are not told whose morality, whose justice, but we know that it was the morality of the English, it was the customary law of the English that was deemed to be superior. And that was the very same thing that happened in the countries that were colonized by the French, those that were colonized by the Portuguese, those that were colonized by the Germans, and those who were colonized by the Dutch in the Dutch Roman tradition, and even those who were colonized by the Spaniards in Equatorial Guinea. There is a sense, therefore, that one of the things that was done as what permit me to use the legal infrastructure at once and legal superstructure was designed to deprecate African ways of doing things. And this can be seen in the very same way that education generally was dealt with. And in many areas that we are familiar with, If you go into the realm of criminal law, for example, one of the things that the British did very quickly was to say that all laws must be written, and if they are not written, then they are not law. And you find that many African dispute resolution mechanisms in the area of criminal law were thus eliminated. In the area of the law of property and land, African traditional tenure systems were dealt a death blow. And those of us who are familiar with land law, as we used to call it a few years ago, in Kenya specifically, I know, they introduced a system that was the torrent system in Australia. If you go into the law of succession, you find that African succession systems were also dealt a death blow. And in the area of marriage, I remember a judgment that came out of Tanzania by the West Indian lawyer and judge, Telford Georges, who, when called upon to decide the marriage between two Africans, said, and I quote verbatim, he said, that the relationship between an African man and an African woman, for want of a better term, cannot be called a marriage, but wife purchase. I'm giving this very broad overview so that we are able to appreciate the manner in which customary law was dealt with. So that when you and I went into law school, the things that we were confronted with when we were studying jurisprudence, it was Hegelian theory. It was the theories of Western thinkers. And if indeed customary law was an option offered at our law schools, none of us took it because we thought that if you are a student studying customary law, then that spoke something about or your imprisonment in the past. And I think that that has persisted so that in the areas where customary law was preserved, it was merely from a very tokenist standpoint. And that being the case, it is to be understood that as we speak now, the entire arena of dispute resolution, particularly where customary law is involved, is very narrow. And in our paper, we are talking about access to justice via the avenue of customary law. Mr. Ogada, as I've said, is going to be a little bit more granular in his presentation, but permit me to give a broad brush presentation in this regard. If you look at law today, we talk about the common law. And our definition of common law, all of us, is informed by our training. And what is our training, even if we deny it? We are Anglophiles. We define things like the English word. When we are told to define the reasonable man, when we haven't thought about it, we still say, even today, the man in the Clapham omnibus. And that tells you that there is a problem because our understanding does not appreciate the nuanced nature of our circumstances. If you are in Ghana, ask yourselves how many people actually understand the common law as handed down to us. We have these courts that are to be found throughout Ghana or Nigeria or Nairobi, but how many people access them? How many people understand the law? In the realm of criminal law, of course, as I've already said, it will be manslaughter, it will be murder, it will be sedition, it will be treason, but the reality is that customary law is not available in that arena. If you go into traditional land system that I've already talked about, the truth is that we'll be talking about inherited or acquired land tenure system. Perhaps Ghana is a little bit better because of the traditional land systems. Zambia is a little bit better in that regard. having usufructuary interests in land. If you go into the area of succession or the definition of marriage, either it is English law or in countries where there is Sharia law, one can say that there is Islamic law. How many people have the opportunity to access those laws, and how many communities therefore benefit? And one can say, therefore, that customary law suffers immensely because of the nature of the colonial Westphalian African state. It is an artificial state with a legal order that is alien and artificial. And for that reason, customary law is consigned into a little corner where its prominence is not seen. And you and me who are academics, the best we do is to moralize about it, is to intellectualize about it, and to philosophize about it. But in truth, we don't use it in a practical sense. But as I conclude so that Mr. Ogada comes in, there is what one may describe as cultural or customary law revivalism. And that revivalism has been informed by certain realities. In the recent past, the revivalist nature of African customary law was seen in its greatest splendor in post-genocide Rwanda, where after the constitution of the International Tribunal for Genocide in Rwanda sitting in Arusha, the administration in Rwanda took the view that the dispute resolution system in that arena was not going to be understood by the people. And they came up, they went back to the traditional system, the gachacha. And believe me, Rwanda enjoys stability now because the gachacha was capable to the extent that is humanly possible to mediate the relationship between the perpetrators of the genocide and the victims of the genocide, which the Arusha Tribunal could not do. I also see cultural revivalism and customary law revivalism in the area or in the arena of the law of property in land. We are now beginning to see traditional tenure systems being given their pride of place. I see that in the area of succession. In Kenya, there are cases now where they say that for purposes of succession, when a child is born out of wedlock, they benefit from the estate of their father, which is in recognition of the African reality that there can be no illegitimate children. And you see customary law beginning to gain traction in that arena. In the arena of marriage, in Kenya law now, it is possible to make a choice of law. There is what one may call a smorgasbord of different ways of marriage. You may choose to be monogamous, you may choose to be polygamous, and all these are registrable. What I am saying, therefore, as I conclude, that customary law deserves to be reanimated because we are discovering by the day that the laws we inherited from the erstwhile colonizers are now beginning to conflict with certain fundamental areas. I know the area of LGBTQ is one that is contentious, but I want to give this as an example. When the British came into many African countries, including Zambia, Ghana, and all these others, they described an offense which you know about, sex against the order of nature, and they described it as sodomy. Today, in England, there is no such offense because same-sex marriage has been legitimized. And Africans are beginning to question, and I believe that those questions are even being asked at universities. How can this be that when they change, we also change in the 21st century? In a nutshell, ladies and gentlemen, I'm saying that indeed African customary law has been in comatose, but we are now beginning to see its revival in its different permutations, and that is a good thing to say, because the critical mass of the peoples of Africa in their different traditions still are much more intimately wedded to their culture and tradition, and that should be translated into justiciable law. I rest my case and invite Evan Sugada to go into the specificities of our presentation. Thank you very much.
Mr. Ogada, you are muted. You are muted. We can't hear you.
I am muted. Did I unmute now?
Yes, yes, we can hear you
Thank
now.
you very much. It's always a tough ask to follow after Professor Lumumba. To granulize morsels from Professor Lumumba is always a hard ask, but I'm going to try my best. For purposes of coherence and ease to follow, I have divided my talking points into 5 areas. I will go through this in the shortest time possible. We have what we call resilience, the masked heritage, the African legal history, the impact, and the future of the stifled customary law and dispute mechanisms. Before I proceed, may I pay my homage and respect to Professor Ndulo. Professor Ndulo, we have benefited immensely from your writings in constitutional law. My brother, Dr. Kamala, thank you very much. I can see you online. Now, in terms of resilience, you have to appreciate what Professor Peter Eke from Nigeria calls the 2 publics. This gives us the nature and understanding of the African state, that we have what we call the civic public and the primordial public. The civic public coheres with the formalized received law, the sedimented colonial law, the statist law. Now, the primordial law is what sustains African cultural mores and law. And this primordial public, rather, has refused to go. It has been resilient, such that after almost 60, 70 years of independence all over colonial Africa, customary African laws have been resilient to resist the emasculation by statist system. Now, in terms of the second talking point, which is the masked heritage, we have consciously been fed, regurgitated, organized history. So for example, Professor Ndulo, who writes in constitutional law, would tell you that he has read and dealt with enough books to tell you of the Magna Carta of 1215. Yet these authors will not tell you that in 1263, we had a constitutional order among the Mande and their constitution, the Kuruk and Fuga. This is not taught to students in Africa, in our law schools. The Kuruk and Fuga had a very rich tapestry in terms of constitutional norms, humanitarian norms, human right claims. These have been masked and veneered under formalist law. In terms of constitutional law proper, the Benin Noir, the ancient kingdoms in Benin, had proper constitutional orders, and we have not stirred our appetite to research into these constitutional orders. West Africa is a rich area in terms of looking at knowledge, institutions, and I believe Ghanaian Professor It, economist Professor It, has done a good job at explaining the history of indigenous African institutions. In terms of what Professor Lumumba talked about, the legal superstructure being designed to deprecate African customary law, we have to understand in the context of my third talking point, the African legal history. And Professor Wana Emcee has done a splendid job. I cannot go through it in the time given. Wana Emcee gives a trisection of the phases of African law. We have the colonial period, whereby law was part and parcel of our socio-political fabric. It was deeply embedded and enmeshed in our societies. Then we have the second phase, which is the colonial period. Professor Lumumba touched on it a little bit. This is the period that was characterized by the emasculation, the neutering of African traditional laws. What tools did the colonialists use? Of course, he has touched on the so-called Repugnancy Clause, whereby African laws and ways of doing things were emasculated, subjugated, deprecated, made less in a denial of our chthonic and cultural way of doing things. So that Ogada's grandfather, who is called Ombok, had to be the quintessential British. Barack Obama's grandfather, who was a cook in the British military, had to behave and be resplendent in the British manner, because we wanted to create enclaves of Paris, enclaves of Lisbon, petit corners of London in Africa. And we had to straitjacket these people in our ways and fashion. The post-colonial phase carries on that duality, whereby we have formal statist law characterized by positive law in a constitutional order that flows from sedimented constitutional documents. And we have the resilient, remember we started with the resilience, the resilient African customary law that is a facet of the primordial public, Peter Eke. Now, the coexistence has been there. And in my own Kenya, we had this tension, where under the Judicature Act, we had the Repugnancy Clause subjugating and demeaning customary law. We've had quite discussion about why we should have the Repugnancy Clause and the Judicature Act to subdue customary law and alien norms, sedimented norms. Now that led to a provision under the Kenyan Constitution, Article 159(3)(b), Repugnancy Clause, nonetheless constitutionalized, whereby we have vague and abstract notions of morality and justice that nonetheless African traditional laws have to go under. So that is the state with many African societies, whereby we have Western statist tools of law that have hitherto and continue to be tools of subjugation and demeaning, deprecation of African law. What has been the impact of the sedimented Western law and the duality of systems? Of course, we've had statist law being preponderant, the civic public. It has dominated, and more we've had subtle bursts of decisions that try to extol customary law. But overall, we've had statist law as an aspect of the civic public preponderating. And that has meant that everything African is demeaned and our chthonic existence as a people is denied.
Mr. Ogada, if you can wrap up, you can be wrapping up.
As I wind up.
Yes, please.
What is the future? Professor Lumumba talked of reanimation. We have to give meaning to ourselves. We have to appreciate our own self. I'll wind up by asking us to hearken to Bob Marley's song. Emancipate ourselves from mental slavery. None but ourselves can free our minds. Thank you.
I would say that's a very good winding up. using that Bob Marley's song. But thank you very much, Mr. Ugada and Professor Lumumba. So we'll go straight into the second presentation. Can I ask all those who have questions, if you could send them to there's a question and answer section or a chat section, so that at the end of all presentations, we will read out your questions to the presenters. Thank you very much. So the next presenter is Professor Chuma Himonga, who is the Dean of the School of Law at the University of Zambia. And the presentation is The Future of Living Customary Law in African Legal Systems. Professor Himonga, are you here?
Yes, I'm here.
Okay, so the floor is yours, madam. Thank you.
Thank you very much. I will keep my video shut because it interferes with the audio. So I hope you don't mind.
Thank you very much. No problem.
All right, thank you for the opportunity to present a very short paper to this conference, which seeks to explore the changing dynamics of customary law in the 21st century. In order to contribute to the theme of this conference, which I've just mentioned, I would like to present some thoughts from a paper I wrote some 9 years ago, which I think still holds for a conference which seeks to explore or understand the changing dynamics of customary law in the 21st century. In that paper, I wrote about the future of living customary African legal systems in the 21st century, with special reference to South Africa. And although the paper is referring especially to South Africa, I think it has some widespread application to African legal systems. Before I go any further, let me just say a few things about what I call living customary law, a term which I think has not become very widespread among a lot of scholars, but particularly among state institutions like courts, the legislatures that apply African customary law, apply or make African customary law. Now, scholars have debated and continue to debate about two concepts of customary law, namely living customary law and official customary law. The distinction between these notions is therefore controversial, as scholars continue to debate whether there is a rigid line between the two forms or concepts of a customary law, or the systems of customary law that are represented by these concepts. It's not my intention to enter this debate. There is another place to debate this, but suffice to say that both sides of the debate seem to agree that there is a point at which the customary law applied by the state institutions, including the courts, cease to reflect the customary communities' customary practices, that is the customary practices that they apply to regulate their lives on a day-to-day basis. Now, the customary law that is applied by the courts, as we know, and it has already been said, has been influenced largely by the received law systems, particularly the doctrine of precedent. And in some cases, customary law norms, if you like, have been codified in legislation. These are the sources of customary law that are used by state institutions, largely to resolve disputes in their courts between parties who claim to apply customary law in their lives. The changes that have taken place in due course, changes on the living customary law or the customary practices that people use on the ground, are such that those practices are completely transformed in many cases to the extent that they cease to reflect what people actually use on the ground, but also become completely alien to those who are governed by customary law. Now, it's these customary practices that people use on the ground, that is, people who are subject to customary law, that I call living customary law. While the official customary law is that law whose source is in the doctrines, for example, of Presiding, is drawn from the Western legal systems, or customary rules that have been encoded in legislation. So these are the two forms of customary law that scholars debate about. The presentation I'm going to make focuses on the distinguishing features between these two forms of customary law. One of which is that living customary law, in contrast to official customary law, adapts to changing conditions of a society in which it operates, whether these conditions be social or economic, or conditions arising from norms of other legal systems. While official customary law, because of its source in the court precedents of the English common law or in legislation, is relatively static and hardly adapts to changing conditions in a given society. So this is just a small explanation of what official customary law and living customary law is. The thing to remember about living customary law, it represents that system that people practice it is adapting, it changes according to changes that are taking place in society, while official customary law is that system which is rather static because it's cast in the precedents of the Western legal systems or in the legislation that purport to encode customary norms, customary living norms. So let me go back to my paper then. In the paper that I'm presenting, Hello? Hello?
Yes, we can hear you.
Okay, thank you. Thank you so much.
You're welcome.
So in the paper that I am presenting, I looked at living customary law in response to the debates that were taking place among scholars that suggested the imminent demise of customary law. And that demise was characterized by a debate or statements such as the end of the road for customary law, the final nail in the customary law coffin, the withering province of customary law, obituary of customary law, and death shadows, that is killing customary law softly. The specific context in which these statements have arisen or were made in different debates include, among other things, the conflict, if you like, the potential conflicts and the actual conflicts that exist or occur between customary law and human rights. And this is obviously a very important point to to the theme of our panel. Other contexts in which these statements arose included the encroachment of the authority of customary law made by legislative or judicial actions in context of customary law reform in post-colonial Africa. They also included the so-called reduced role of customary law in modern African societies due to the rapidly changing social and economic conditions. As I have already intimated, the common denominator of all the statements that I started with about the imminent demise of customary law was the anticipation, or is the anticipation, of an uncertain future for this system of law, that is the system of customary law. However, I argue in that paper that while challenges about its application persist, living customary law is likely to assume, and it has already been said about revivalism of customary law, that customary law is likely to assume, if not maintain, a prominent position in African legal systems and continue to regulate the lives of the majority of Africans on the continent in the 21st century and beyond. And here I'm talking about living customary law continuing to exist or to maintain its position in regulating the lives of Africans. My argument is not premised on what has been called deep or strong legal pluralism per se, but rather on observable contemporary indicators that suggest that customary law, living customary law, will actually continue. And there are three of these that I want to mention. The first one, which has already been mentioned by the previous speakers, is the toning down of the legal theoretical debates about the idea of law, which tended to exclude customary law from being law, but rather being a social system of control. That the debate, the dying of that debate has given opportunity to explore notions of customary law as law, and not simply as those systems of law that must be relegated, as has been mentioned, to areas of regulation of African lives than law itself. The second indicator is the explicit and implicit constitutional and judicial recognition of the concept of living customary law, particularly by the courts in South Africa. The third is the view from research that living customary law is potentially more responsive to protection of human rights than official customary law. So viewed against this background, and particularly these indicators, I would argue that statements anticipating the end or looming demise of customary law or about the uncertain future of this system of law must be restricted to official customary law as opposed to living customary law. By its nature, official customary law is unresponsive to change, as I have just indicated. It becomes obsolete with the passage of time. Additionally, official customary law is often viewed as inimical to the rights of women and children generally. Unfortunately, most people who speak about the conflicts between customary law and human rights do not seem to appreciate this distinction between official and living customary law. And I want to urge the participants in this conference and others that it is absolutely important to distinguish between living and official customary law when we are talking about conflicts between human rights or about the future of customary law. So official customary law is often viewed as inimical to the rights of women and children generally. In contrast, living customary law's adaptability to change, which I have mentioned, underscores its potential to live on and to become the customary law of the 21st century and beyond. Although not...
Prof, you should be wrapping up.
Yes, I'm going to wind up just now. How many minutes do I have?
Well, you had 15 minutes, and I think you've used 15.
All right. Okay, so what I'm going to say is that this distinction between official and living customary law is absolutely important as we think about the future of customary law, what role it's going to play, in a changing Africa. And I want to say that regarding the potential of living customary law to protect human rights and to fit in the changing conditions of Africa, whether socially or economically, I want to say that recent studies in Southern Africa in particular have shown how, in fact, living customary law is adapting to notions of human rights, even being adopted by people who have not heard anything about the principle of equality in formal legal documents and other constitutional provisions. And also, I do want to mention in conclusion that the dynamism of living customary law is worth exploring in our understanding of customary law in changing Africa. If we look at some of the studies that have shown that within the context of conflict, if you like, or contestations between official living customary law and constitutional human rights, people actually use both the notions of living customary law and notions of equality. People who have no knowledge of these formalistic presentations of human rights in the documents that we are looking at, like constitutional documents. So in my view, the future of living customary law must be seriously considered if we are going to think about the role customary law is going to play in the future. And also, we should be looking at understanding how living customary law adapts to change. What are the conditions, in fact, that influence that change? How do contestations between living customary law and other norms of law that operate within its sphere shape or define the norms of living customary law? I thank you for your attention.
Thank you very much, Professor Himonga. I should mention to all the presenters that if because of time limit you are unable to get a point across, we have a number of questions already lined up for almost every person who has spoken. So in answering these questions, you will still have the opportunity to get whatever point that you may not have been able to make made at that time. So the next presenter is, we have two presenters, Dr. Ekato and Dr. Newman Richards. Dr. Ekato is a senior lecturer at the University of Derby in the UK. And Dr. Richards is a lecturer at the Faculty of Law of the University of Nigeria. And the presentation is titled, "The Continued Relevancy of Customary Arbitration in Nigeria, Implications for the Recent Supreme Court Judgment in Umiedi versus Chubunze." So honorable presenters, the floor is yours. Thank you. You have 15 minutes.
Thank you very much, Professor. My name is Dr. Egusa. I'll be doing the presentation is going to be in two parts. I will do the first part in about 8 to 9 minutes. Then my co-presenter, Dr. Newman, will finish up with the other part of the presentation. I also want to thank you for this opportunity to present at this conference. So before I start my presentation, I will just make some few comments. I do a bit of research on pre-colonial legal system in Africa, and I was very also asking if anybody has got any publications, any articles in respect of pre-colonial legal system in Africa. I'll be very, very grateful. because I'm also engaging in research in that area. So my presentation today, so we are discussing customary law, customary arbitration. As Africans, customary law is second nature to most of us. So in this particular conference, we've got like an introduction. We're going to talk about evolution of customary law, customary arbitration, traditional taking, and the relevance of the recent Supreme Court decision and proposals for reforms and implementation. So no matter where we stand in terms of our ideological slant, in terms of customary arbitration in Africa, it plays a very, very important role on the continent. So customary arbitration is a very, very significant part of customary law in Africa. So I'm not going to go into the argument of whether we have African customary laws or there should be an African common law. So what we are going to discuss is just focus on the relevance of customary law in Nigeria. So what is customary law? When we refer to customary law, what do we mean? So in a paper by Dr. Wambwezi a few years ago, it defines customary law as a starting point of Nigeria's legal history. Before the emergence of colonial rule, customary law held sway and enjoyed monolithic application in geographical territory known as Nigeria, composed of diverse politically and legally independent nationalities. So before the advent of British colonialism and what we now know as Nigeria, customary law was a prevailing norm in the southern and some parts of northern Nigeria. So simply each of the settlements or tribes had their distinct identity, administrative techniques, and methods of governance. So customary law was like the way of life of many Nigerians at the pre-colonial time. So in terms of the Nigerian legal system presently, customary law is one of the sources of the Nigerian legal system and generally said to be unwritten, largely unwritten as opposed to English law, which is written. So there's no, arguably, Nigeria in different parts of the continent, there's no generic or uniform customary law in Nigeria. So hence different communities or different tribes, have got their own unique customary law practices. So as I mentioned before, customary law in Nigeria is one of the sources of the Nigerian legal system. Generally is said to be unwritten as opposed to English law, which is written, notwithstanding that much of the modern or post-colonial customary law is unwritten in Nigeria and other parts of Africa. There has been a rising body of court decisions setting down customary rules of law as the authors judge them to be. Therefore, presently, it's not much easier to state the rule of customary law on a particular issue. Present Nigeria, customary law, as I said, is one of the sources of a Nigerian legal system. So, notwithstanding that much of the post-colonial legal customary law is unwritten, as I mentioned before, it's much easier to state the rule of customary law on particular issues. So, according to Professor Oba, he says that writing is now recognized in customary transactions and some customs are not contained in statutory declarations, notwithstanding that the customary law is said to be largely unwritten. Now you have some written aspects, written slants to customary law in Nigeria. So what are the characteristics of customary law? They include flexibility, diversity, and it's largely unwritten nature. So how do we define custom? How do we define customary law? Section 258, subsection 1 of the Evidence Act defines custom in a particular district as a rule which in a particular district has from long usages obtained the force of law. So what are the matters which customary law concerns? They are primarily concerned with simple cases of contract, mainly debts, torts, and family law and succession. So unfortunately, customary law has been relegated to the backwaters of the Nigerian legal system. However, notwithstanding the sort of restriction, the lack of relevance given to customary law in Nigeria is still very, very important in personal matters such as marriages, land contract, succession, amongst others, especially in the rural and even in the urban areas in the country. For example, in some parts of the country now, you have some kings and some emirs and so what they call obas. They actually have traditional palace courts where people go to resolve their personal problems at the palaces of these kings. So for example, traditional palaces represent the resolution of customary law disputes in modern day Nigeria. Prior to the coming of the British colonialism, customary law extended to both civil and criminal cases. Today in Nigeria, customary law does not extend to criminal cases, but solely for civil matters. So, according to Section 36, Subsection 12 of the Nigerian Constitution, there's no criminal customary law in Nigeria. So basically, customary law in Nigeria focuses on just civil issues and not necessarily criminal matters. So what is customary arbitration? So customary arbitration is a very, very important slant of customary law in Nigeria. So African societies before colonialism, we had a system of basically, before the advent of colonialism, African societies were socially organized with clear governance, structures, and effective dispute resolution mechanisms, which included mediation and customary arbitration conducted in accordance with the customs and traditions of the people. Customary arbitration can be defined as arbitration of disputes founded on the voluntary submission of the parties to the decision of the arbitrators, who are either the chiefs or elders of their communities, and the agreement to be bound by such decisions. Also, the Supreme Court in Nigeria has provided various definition and explanation of customary arbitration. So however, there's a massive distinction between customary arbitration and your conventional Western style arbitration. A very, very big difference between customary arbitration and the Western style arbitration. That is, customary arbitration is private. Customary arbitration differs from the Western type arbitration in some ways. For instance, why Western type arbitration is private in nature with participation restricted to the parties, arbitrators, witnesses, and any person who has a specific role to play. Customary arbitration, on the other hand, is not private at all, as all members of the community are allowed to be part of the session, except in some cases where women and children could be excluded. So customary arbitration is designed to promote reconciliation among parties, and there's also a declaration that no one is guilty or innocent. Hence, customary arbitration is an informal method of dispute settlement in Nigeria, notwithstanding that. So, notwithstanding that customary law, including customary arbitration, are not generally codified in Nigeria, the parties to customary disputes mostly respect the decisions that are reached in customary arbitration and its binding resolutions. So, basically, there have been a long line of cases on what are the sort of the characteristics of customary arbitration in the country. I'll just read out the 5 characteristics that we've been able to put together. One of them is that the parties voluntarily submitted the matter in a dispute on an arbitration for one or more persons, that the parties agreed either expressly or by implication that the decision of the arbitration will be accepted as final or binding. 3, that the arbitration was in accordance with the custom of the parties or their trade or business. And number 4, that the arbitrators reached a decision and published their award. And finally, number 5, that the decision or award was accepted at the time it was made. So another part of customary arbitration in the country is traditional oath taking, which is a very important part of customary arbitration. So I'll just finish my part of the presentation, and my colleague, Dr. Newman, will take over from me at this point.
Dr. Richards, you are muted.
Okay. I'll start by thanking the organizers of this program for this opportunity, this conference for this opportunity. I will pick up from where my colleague Dr. Egusa stopped. No doubt, African indigenous dispute resolution systems have suffered relegation since the advent of colonialism. Unfortunately, this relegation is further entrenched by the perception and attitude of customary arbitration by some jurists and scholars. However, recently in 2020, the Supreme Court of Nigeria in Emcee and Chibweze fortified the dispute resolution process of customary arbitration by oath taking, when it held that where parties who believe in the efficacy of a juju resort to oath taking to settle a dispute, they are bound by the result. And so the common law principles in respect of proof of title to land no longer applies, since the proof of ownership of title to land will be based on the rules set out by the traditional arbitration resulting to oath-taking. This decision is quite commendable as it resolves earlier inconsistencies in judicial pronouncements on the validity of traditional oath-taking, and it fortifies the earlier decision of the Supreme Court in Onyenge and Ebere. Furthermore, it re-echoes the functional utility of customary arbitration in Nigeria. I say so because before this decision, there have been some harsh criticisms of traditional oath-taking, even from the Supreme Court. For instance, in Nwoke and Okere, a decision of the Supreme Court delivered in 1994, Kutigi JSC, who read the lead judgment, criticized customary arbitration by oath-taking and held that the juju method, as cheap and quick as it may appear to have been, had its own disadvantages. For example, I'm quoting his judgment. For example, you cannot put a juju in the witness box for any purpose. Its activities, methods, and procedures will appear to belong to the realm of the unknown, even though the effects may be real in the end. The worst of it is that a juju judgment or decision is not subject to an appeal like the one we are witnessing in this suit. So that unless and until the juju descends to the level on which we can all understand its workings, it will be difficult to enforce its decisions in a law court. We have come a long way from the oracle. Similar to this kind of harsh criticisms for customary arbitration by oath-taking, Professor Nwakobi said in one of his papers that practice of oath-taking is not only fetish, it is barbaric, uncivilized, outdated, anachronistic, criminal, illegal, but also contrary to Nigerian jurisprudence, as it is superstitious, mysterious, and spiritualistic. These criticisms were largely influenced by Western education and the impact of Christianity and Islam in Nigeria. They underscore how customary law is perceived in certain circles, where attempts are made to validate customary law using the philosophy of English law. Thus, the decision of the Supreme Court in Umadi and Umweze represents hope and emphasizes the need for African jurists to uphold the philosophical underpinnings of customary law. Based on the foregoing, we are proposing that there is need to strengthen the constitutional position of customary law and by extension, customary arbitration in Nigeria, drawing from the experience of some other African countries where their constitution recognizes the role of customary law in dispute resolution. For instance, South Africa, Kenya, and Mozambique. In the South African Constitution, Chapter 12, Section 211 and Sections 212 of the Constitution of South Africa in 1996 provides recognition to customary law and recognizes the traditional institution and the role of traditional leadership. Specifically in Section 213 mandates the court to apply African customary law where appropriate. Similarly, in Kenya, Article 1592 2C of the Constitution of Kenya provides that alternative forms of dispute resolutions, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms, should be promoted. Also, we can also see that in the Constitution of Mozambique, Article 118, which provides that the state shall recognize and esteem traditional authority that is legitimate according to the people and to customary law. The state shall define the relationship between traditional authority and other institutions, and the part that traditional authority should play in the economic, social, and cultural affairs of the country. These provisions demonstrate strong support for customary laws, customary arbitration, and customary law institutions in those countries. Hence, Dala and Kwanga had observed that from recent constitutions and constitutional amendments, there's an increasing constitutional recognition of customary law in Africa. For instance, the examples we just gave in South Africa, Kenya, Zimbabwe. But conversely, the constitutions of places like Cameroon, Gabon, Nigeria, Rwanda, and Tanzania have the least recognition of customary law. We therefore agree with Dala that African constitutions should spearhead the integration of customary law with state law by adopting the foundational values of indigenous laws as constitutional principles. In concluding, the decision of the Supreme Court in Omadi and Chibweze is commendable as it re-echoes the need for judges to evaluate customary laws from an indigenous perspective. This was aptly demonstrated by the Supreme Court as it avoided the trap of looking at the validity of customary arbitration by oath-taking from a foreign perspective or the prism of Western civilization and religious proclivities. Therefore, the attitude of government institutions, the executive, the legislature, and the judiciary should be to preserve and strengthen customary arbitration. While customary arbitration is upheld and enforced in the courts in Nigeria, more strategies need to be adopted, especially by the government, to elevate the status of customary arbitration in Nigeria. This is where the legislature must rise to the occasion by changing the perception of customary law from a subsidiary law to a principal law. This is arguably in line with the recommendation of the United Nations Development Program that due to the reliance of many Africans on the traditional justice machinery, African countries must endeavor to improve the quality of their indigenous or traditional justice systems. Hence, this paper recommends that the status of customary law should be elevated in Nigeria and given constitutional status akin to South Africa and Kenya, where customary law enjoys a higher constitutional recognition. Thank you. That's the end of our presentation. Thank you.
Thank you very much, Dr. Richards. You were right on the dot with your times. Thank you very much. Our next presentation, the last but not the least, is from Professor Raymond Tuguba of the School of Law of the University of Ghana. And his topic is Customary Law Revivalism, 7 Phases and the Evolution of Customary Law in Sub-Saharan Africa. So, Prof, the floor is yours. Thank you very much.
Good afternoon, everyone.
Good afternoon, Prof.
I just shared my screen. I would like to confirm that you can see it.
Yes, we can.
So, as you can see, my presentation today is titled Customary Law Revivalism, 7 Phases in the Evolution of Customary Law in Sub-Saharan Africa. I would like to convey 3 things in the course of the next few minutes. The first is that customary law has been the law in Africa, is currently the law in Africa, and will be the law in Africa predominantly going forward. I know that's a bold statement, but I'm about to prove it. The second message I would like to convey today is that it's possible to identify 7 distinct phases in the evolution of customary law over several centuries. And I have christened these phases Pristine Customary Law, Judicial Customary Law, Codified Customary Law, Statutorily Instituted Customary Law, Complementary Customary Law, Insular Customary Law, and Declared Customary Law. The third and last message I'll be conveying in this presentation is that customary law's resilience and fecundity is propped up by certain contemporary factors, chiefly neo-constitutionalism, participatory democracy, subsidiarity, and anti-globalization. These are the 3 key messages in today's presentation. Let me start with the first message. My proposition is that customary law has always been the law in Africa. It used to constitute 100% of the law in Africa until Islamic influences from the north, European colonization and Christianity from both the south mainly, and in most of Sub-Saharan Africa. Then Euro-American neocolonialism influences of the internet and the media. And in current day Africa, the attempted Asian capture. So it used to be the law, but all these other influences are affecting it in some measure. Customary law is also still predominantly the law in Africa. Chunks of land law, if you look at the bigger paper that I have developed, I've established the percentage of land holdings in various African countries that are still held under customary tenure and under customary law. The same with family law. A huge chunk of our family law in Africa is based on customary law. And of course, the law on traditional authority is based on customary law. As I will establish later on, at the end of this presentation, customary law will be the predominant law in Africa going forward. We move on to the second message. The second message I seek to convey is that we can identify 7 distinct phases in the journey of customary law through time. I'll go through these very quickly. The first is what I call pristine customary law. And this is customary law as it was before external contacts. And depending on your ideology, those contacts can be said to be good or to be said to be pollutants. But whatever happened, pristine customary law was gravely decimated, reconstructed from distorted recordings of people like Rattery and other people who recorded or attempted or purported to record customary law. Errors in translation because they didn't understand the language and they had to use translators. Self-serving accounts of customary law and biased accounts. So it's really difficult today, in most cases, to discover what the pristine original customary law on any issue in Africa was, due to the effect of these pollutants. The second phase in the evolution of customary law is what I call judicial customary law. And most lawyers know this. This was the attempt to supplant pristine customary law using what we call the Repugnancy Clause. So the Repugnancy Clause eviscerated pristine customary law by ensuring that the European notions of natural justice, equity, and good conscience were used as the standard against which customary law was measured. And where customary law fell short, it had to fall. So in the bond of 1844, for example, that was entered into between the Southern chiefs and European colonizers, this phrase that you see on the screen appears, quote, thereby molding the customs of into the general principles of British law. So there were some positives that arose from judicial customary law. So for example, judicial customary law would abolish human sacrifice, would abolish panyarring, and abolish the killing of twins. But there were also some horrible negatives that arose from judicial customary law. For example, in the case of Kuofio and Mensah, an 1898 case, the colonial secretary ordered the chief of Winneba to withdraw bylaws that the chief had made. So under customary law, we had laws, and some of them were characterized as bylaws. So he ordered the chief to withdraw bylaws which prohibited the use of some 3 nets. Now, the chief claimed that these nets were the cause of overfishing. Now, the response of the colonial secretary to that was interesting. He said he was not able to agree with the chief of Winneba because the best fishing net is the net which catches the most fish. So this is an instance where instead of positively molding customary law, judicial customary law was actually destroying aspects of customary law that were based on sustainable fishing and sustainable development. So it's wrong to assume that all of the time judicial customary law was positive because it changed negative aspects of customary law as we are taught in school. That is only half the story. There were very progressive aspects of customary law that were decimated by judicial customary law. The third phase in the evolution of customary law was codified customary law. And I would like us to draw a distinction between codified customary law and statutorily instituted customary law. The two are different. Let's start with the third one, which is codified customary law. This occurs when aspects of customary law are either written into codes or laws, or where they are compiled and used to assist judges when they have to decide on what customary law of a certain segment of the society is. So for example, sections 5 to 8 of the Ghana's Interstate Succession Law says that the estate of a person who dies without making a will, a certain portion of it would devolve according to the rules of customary law. In other words, customary law of interstate succession has now been written into the interstate succession law. In other areas, there is mass codification of customary law. So in Ghana, in Nigeria, in Kenya, there have been attempts to codify lots and lots of customary law so that it's available in one place and can be utilized when needed. When this is done, and together with the writings of publicists on customary law, they are now used more or less as codes in the determination of customary law. This is why in Ghana's Courts Act, under ascertainment of customary law, it is provided that the court would examine reported cases and textbooks and other sources to find out the appropriate customary law. The fourth phase is statutorily instituted customary law. Now, we need to distinguish this from the third one, because in statutorily instituted customary law, new rules of customary law are instituted. In the third one, existing rules of customary law are put in statutes or put in codes or codified. But in this case, new rules are instituted by legislation. For example, Ghana's head of family accountability law, making the head of family accountable, is a new rule of customary law. The repeal Ghana customary marriages registration law is another example where there was an attempt to get customary marriages registered. The fifth phase in the evolution of customary law is complementary customary law. In many instances, the Constitution, statute, common law are insufficient to regulate aspects of customary life. And so customary law is used as a complement, hence complementary customary law. This occurs a lot in land law, in family law, in ADR, and even sometimes in contracts and torts, because in Ghana's Courts Act, it is said that you can apply the personal law of a person for the resolution of issues of contracts and torts. And this personal law is usually the customary law of the person. The sixth is insular customary law. This is like almost the opposite of the previous one. This is a situation where customary law is not complementary. Customary law is actually the basic rule of the game. And then other forms of law are rather complementary. So we are turning it around. So for example, in the area of customary marriages, the law is almost 100% customary law. In the area of customary land tenure, it's almost 100% customary land law. In the area of chieftaincy, it's almost 100% customary law. Other laws are then complements because the great majority of the body of law in these areas are drawn from customary law. So for example, about 80% of lands in Ghana are held either by families or by chiefs and tindanes under customary law. And almost 100% of marriages in Ghana are celebrated partially or wholly under customary law, even if another system of marriage is followed through after the customary law marriage. The last phase in the evolution of customary law is quite recent, is what I call declared customary law. This is where through autochthonous indigenous processes, declarations of customary law are made either to abrogate or adapt or institute new rules of customary law. If you look at Ghana's Chieftaincy Act, for example, it provides that the process can begin from the traditional council, then to the regional house of chiefs, to the national house of chiefs, and then approved by the minister for chieftaincy. It is then taken to the Attorney General for consultation and is issued as a legislative instrument. This is what we call declared customary law. So these are 7 types of customary law that are quite distinct and that have evolved over time. My last message in today's presentation is that customary law's resilience and fecundity is encouraged and promoted by certain factors. The first factor is neo-constitutionalism in Africa, the phase where African states are beginning in the 1990s, developing new constitutions where they are inscribing and guaranteeing customary law as law in Africa. That's the first thing that would ensure the survival and growth of customary law going into the future. The second is participatory democracy. Neoliberalism privileges participatory democracy, and participatory democracy inevitably leads to the use of local systems, like Professor Lumumba mentioned in the case of Gacaca in Rwanda, the use of local systems to promote democracy. The same goes for neoliberalism's emphasis on subsidiarity. Subsidiarity is the insistence that matters that can be better dealt with at the local level are dealt with there and at no other level. Now, because of that emphasis on subsidiarity, matters are again pushed into the domain of customary law, because that's customary law operates and is master at the local level. Finally, neoliberalism loves anti-globalization, forces that attempt to reform the bad effects of anti-globalization, which means that there are attempts to localize more than to globalize. By emphasizing anti-globalization, you are pushing matters down to the local level, again, where customary law is master. And that's why I conclude that going forward, these liberal democratic values of neo-constitutionalism, participatory democracy, subsidiarity, and anti-globalization can only promote customary law. In conclusion, customary law has been the law in Africa. Customary law is the law in Africa, and customary law will be the law in Africa going forward. Thank you for your attention.
Thank you, Prof. Thank you very much, all the participants, panelists. So we come to the point where we ask questions and of you, our dear panelists. And these questions, we have a number of questions from participants, but I have a few questions myself. So I will go to my questions. I will ask the questions, and then the panelists can take them in the order in which I asked them. I don't have questions for all the panelists, but a few panelists. I'll start with Prof. Tuguba, and I'll ask the others as well. Prof, your presentation sort of confirms something that I've always believed. I teach jurisprudence, and traditionally we have taught jurisprudence based on schools of jurisprudence, positivism, natural law, legal realism, etc., etc. Your characterization or division of customary law into 7 phases confirms what I've always believed, that law per se straddles different aspects of human life. It wears different hats. So you may have positivism at a certain point in time. You may have naturalism at a certain point in time. It evolves to legal realism, or sometimes there is a mixture. So you cannot come out to say definitely that there is a positivist conception of law per se. So I'm just wondering whether you disagree or agree with this. So that it will be the question for you. My next question goes to Dr. Ekato and Dr. Newman. And this is just to seek a clarification. I think in your presentation, you mentioned constitutional provision that basically states that customs and traditions should be applicable where appropriate, which in a way confirms that customary law arbitration is acceptable. But your presentation seems to suggest that maybe it isn't. So I'm wondering if you could clarify that. Is your objective to suggest that customary law arbitration should take the form of something in the nature of a choice of law rule, or should it be more structural in the sense that there's probably an office for customary law arbitration, etc., in the Nigerian judicial structure? So that is the question for Dr. Ikusa and Dr. Newman Richards. And finally, my third question goes to the first presenters, Professor Lumumba and Mr. Hold on a minute, I'm sorry, the name escapes me just now. Mr. Evans Ogada. Okay. You talk of an emasculation of African customary law. I looked at your abstract, which proposes something in the nature of the acceptability of traditional justice mechanisms. I see some sort of like a tug of war going on in your presentation between what I would call the spirit of the law school, which is a historical, and the living law school. And I'm not sure which of them you would suggest best supports your thesis. So those are the 3 questions. And maybe we can take the responses in the order in which I posed them. First, Prof. Atuguba, then we go to Dr. Newman, and then we come to Professor Lumumba and his presentation. So, Prof, the floor is yours.
Thank you, Prof. Your question is a big question. Customary law and jurisprudential thought. Part of the reason why I have been researching on this in the last 15, 16 years is because I believe that we badly need to reform the law school curriculum in Africa so that we can privilege customary law and African jurisprudential thought to match the African reality. And once we've done that, we can then, taking off from there, do a comparative analysis of global themes in jurisprudential thought relating to naturalism, positivism, realism, and so forth. What we do now in our law schools is to start off from the global themes and then do some cursory mention of African legal thought. I think that that is turning the thing on its head. If we continue to do that, we would continue to experience the intellectual schizophrenia that most of us African intellectuals suffer under. Thank you.
Thank you very much, Prof. And so the next question was to Dr. Newman and Dr. Ikato. Yes.
Thanks very much. Thanks for your question. For a very good question. In terms of the sort of the tone and the objective of our paper, yes, we're in support of customary arbitration. Yes, we're in support of what is happening to customary arbitration, but in the Nigerian context, in our view, there appears to be this lacuna in terms of in the Nigerian constitution. Yeah, there's the Nigerian government is supposed to respect the culture of the people, but it's a part of the constitution which is called a non-justiciable part of the constitution. So we felt, if you use the example of South Africa and the way South African constitution and other parts of Africa have actually brought customary law to the front burner, that will be one step in the way to achieving the aims and objectives. But in terms of conflict of laws, we are not saying that customary law has to be customary arbitration has to be compulsory for everybody. So one way to go for it, we have customary courts in Nigeria, which are courts which are developed by government, but there's a role that the traditional judiciary, traditional courts led by palaces play in the Nigerian customary architecture, and there appears to be a gap in that regard. What is the legal status of courts established by palaces in Nigeria? Should they be backed up by governments, or should the government make laws? For example, you have customary laws, specific laws in South Africa and other parts of Africa that make specific laws regulating the operation of these traditional courts. So our main idea, one of our suggestions, customary arbitration is a very fantastic initiative, but what's the way forward? So most of the decisions are from courts, there's no sort of a drive from the Nigerian government or Nigerian institution to elevate the status of customary law. Yeah, that's why we say it appears to be part of the backwaters of the Nigerian legal system. So I don't know if that answers your question.
Yes, it does. Thank you very much. Ms. Ogada?
Can you hear me?
Yes, we can.
Professor Lumumba has taken leave. He's turning to other issues. On his behalf, I will answer our question on the articulation of African law. Yes, Professor Kwao, as you rightly notice, particularly with the Kenyan context, that tension does exist. I would like to give the following examples. For example, our constitution rightly recognizes culture and cultural, African traditional cultural dispute resolution mechanisms from the preamble, Article 11, Article 44, but that is emasculated by the statist, formalist structures within the Constitution. Because whereas culture and traditional cultural systems are recognized, these are subdued and formalist systems. For example, Article 159(3)(b) of the Constitution brings in the Repugnancy Clause. These African traditional mechanisms to resolve disputes must be subject to abstract and theoretical notions of justice and fairness, which is just putting in the Constitution what we had in the statute as the Repugnancy Clause. How do we resolve this tension? I think is it Professor Atuguba? He nailed it for me, and thank you very much, Professor. I join in with saying that African customary law is chthonic, it's resilient, we have to accept it. And when we accept it, we have to delink our minds from sedimented Western cultural legal system and sedimented positivist law, so that we give African customary law meaningful space to grow. Thank you.
Very much, Mr. Ogada. Okay, so now we go to the questions from the participants. We have a number of questions posted in the question and answer session, and I also have questions sent to me by WhatsApp. So what I'm going to do is I'm going to read 3 questions at a time. The respective members of the panel can deal with that, and then we go to the other questions. Okay, so the first one is for Professor Lumumba, and this I'm going to read it out verbatim, and it says this. Nowadays, Professor Lumumba submits that we have a smorgasbord of marriages in Kenya. Therefore, I would like to ask Prof whether in his view the court's decision in the S.M. Otieno case is still good law today, if it ever was. Where should an African man be buried if he dies intestate and his clan desires to inter him at his ancestral home, while his statutory wife wishes to accord him a Christian burial elsewhere? So that is the first question for Professor Lumumba and Mr. Ogada. The next question is to Professor Chuma, and it's as follows. Why would living customary law be more in line with human rights? I understand that they have the ability to move in that direction, but don't we also see some practices moving towards less equality / inclusion? Is living customary law not in principle amoral? It is just what is found on the ground, and is not part of the critique on the Concord that it only makes the living customary law argument when the change is in line with or towards better human rights. And the third question also goes to Professor Lumumba. So after that, we'll take the answers and then I'll go on to more questions. So the third question to Professor Lumumba and Mr. Ogada, it says, you speak of the repugnancy clause and that we need to free ourselves from the mindset that customary law needs to be in line with European morality. Many countries have replaced the repugnancy clause with a clause that customary law need not to contravene the Constitution. Would you regard that as a post-colonial version of the would you regard that as a post-colonial version of the repugnancy clause, or as something completely different? And if something similar, do you then feel we do not need a constitutional check on customary law? Okay, since Professor Lumumba and Mr. Ogada have 2 questions, Professor Chuma has 1. I think we'll go for Professor Chuma's response first, And then Mr. Ogada can take the two for him and Professor Lumumba. So,
thank you very much, moderator, for that question. Can you hear me?
yes, we can.
And I thank the person who raised it, because that's one point I didn't have a chance to make in my presentation. My paper does not argue that every customary law or every norm of living customary law is in line with human rights. That's not my argument. My argument is simply that because of the nature of living customary law and its ability to adapt to changing conditions, and research has actually shown that customary law is, that's empirical research, by the way, not the book research that we normally do, desk research, but empirical research, particularly in Southern Africa, has shown that customary law on the ground does adapt to notions of human rights, even though they are not cast in the same manner that human rights are cast in the documents, human rights instruments. So the point I'm making is that because of its flexibility, because of its evolving nature, and because of its adaptability to changing conditions, which may actually include and do include, human rights changes or conditions in society, living customary law has a better potential than official customary law, which has been paraded for years and centuries as customary law in Africa. So that's the point that I am making. On the point that, in fact, the courts, particularly in South Africa, have recognized living customary law passively. There are two ways that they have done this: passively, or recognized it in terms of adapting it or changing it. But I want to talk about passive recognition, which the question is referring to. That's when a court applies customary law because it is actually in line with human rights. And the questioner is right, that is happening. But to me, that already shows that, in fact, there is customary law that is compatible with human rights on the ground before the courts even choose to apply it. So I think it actually strengthens my point about the potential of living customary law to protect human rights. So let me underscore this point. It's not every norm of customary law that is in line with human rights, but it has better potential to protect human rights.
Okay.
I end contribution.
Thank you very much, Professor Chuma. So, Mr. Ogada, would you like to take the two questions that were thrown your way?
Thank you, Professor. Now, the first question on the SM Otieno case, to put it in context for our international viewers, the SM Otieno case involved a burial dispute involving one prominent lawyer in Kenya. Now, the dispute before the court was where was the deceased to be buried, having that he didn't have a will. Now, we have had this discussion before with Professor Lumumba, and we share the view that SM Otieno was rightly decided by Justice Bosiri at the High Court, and the affirmation of the Bosiri decision at the Court of Appeal was spot on, because the High Court decision decided the SM Otieno case on personal law. Basically, the man SM Otieno, how did he live? How did he conduct himself as a question of personal law? And the court rightly decided that this man, who came from the western part of Kenya, and specifically from the Luo community, had lived himself as a bona fide Luo. So being a Luo, he was properly to be buried in accordance with Luo customary law. So SM Otieno properly decided. The second question on the repugnancy clause, Article 159(3)(b). Yes, it incorporates abstract notions of morality and justice. and subdues customary law to human rights, in addition to the abstract notions of justice and morality. Justice and morality is not defined on Western or sedimented notions of justice. Are we saying that our traditional African communities do? I want to challenge people here. The Somali customary law has 6 composite elements. And those of us who are teaching jurisprudence, I heard of a brother somewhere who is teaching jurisprudence somewhere. Interrogate the Somali customary law legal system. It is just as rich and fecund, if I could use the term employed by Professor Atuguda, to compete with any civilization out there. So let us cross-pollinate with external experiences, but nonetheless, try to remain pristine and intricate in terms of basic elements of our traditional customary laws and traditional dispute resolution systems. Thank you.
Thank you very much, Ms. Ogada. So I'll go to the other questions on the posted on the question and answer session. So I will ask before, go through the first 3 questions, and then we'll take it from there. This question says, if not documented, wouldn't some portions, if not significant aspects of significant aspects of customary law be lost over time, considering the mode of transmission? Now, this was not indicated as going to any of the panelists. So any of you who feels able to answer it can answer that. The second question is directed at Professor Lumumba, and it says, how do you ensure that presiding officers interpret customary law correctly in our courts without infringing on the entrenched human rights, such as equality and dignity in our constitutions? In South Africa, we have seen many different interpretations of certain aspects of customary law. For example, when is a marriage concluded, that are not cohesive? Do traditional leaders, as the custodians of these traditions, have a role to play in our judicial system? And the third question goes to Dr. Ogada. How do you see the African customary law as a scientific discipline that should fit well within the positive and empirical beliefs? And I would ask the panelists to keep their responses short so that we don't far exceed the time. So it looks like 2 of the questions are going to Professor Lumumba and Mr. Ogada, and the third one was just to any of the panelists. So who wants to go first?
Sorry, may I go first on the
Yes.
The codification customary law, documentation of customary? I think this is a concern that is always raised about the nature of customary law. The flexibility we are talking about, the adaptability is precisely because it's an oral system of law that is applied, by the justices, if you like, or the dispute resolution forums to fit the circumstances and therefore adapted according to changing needs. The cost of recording customary law is known since colonialism, and that is, it has been mentioned in one of the presentations, is that in the process of writing it down, customary law gets distorted. It gets, misconstrued. It gets to incorporate norms of customary law at a particular given point in time and fixes it in that code. In other words, it actually becomes useless as time passes because it does not change readily to meet the changing circumstances. In my view, I think that if customary law is developed largely by the courts, as opposed to actually encoding it in statutes or incorporating its norms in statutes, it will not lose much of its significance or much of its content. So I think along with how customary law can play a role in the future, we should also be thinking about how it should be managed in context of change, how it should be applied by the state institutions. Thank you.
Thank you, Professor Himonga. Dr. Gada.
If I may respond to the first question, how do we ensure that presiding officers stick to the content of customary law? It's a challenge. And I listened keenly when Professor Atuguda was presenting, and I've learned something from him. Perhaps it's something that we could borrow from Kenya. The regime he prescribed from the Chieftaincy Act of Ghana, that is an appealing way to ensure that customary law makes meaning, is malleable to modern way living, but nonetheless has relevance within the society that it operates. And for example, in Kenya, we have Sharia law applying to Muslims because under the Constitution, Muslims in aspects of marriage, death, and such like personal matters is governed by Sharia law. That's the way to go. Second question, African law as a scientific field, whose science? How do we construe it? African traditional law is basically a socio-political phenomenon. So if we accept it as such, then we will get some headway. One of our governors, a lawyer in this country, always jokes that he comes from a community called the Kamba. He says that the Mkamba will fear the traditional oath, but will gladly go to court and take the Christian Bible and swear by it and lie. But that person will not lie swearing to the traditional oath. Why is this person very much respectful of the traditional oath, but will carry the Christian Bible or the Quran and still lie? There is something reverent or heavy about the traditional oath. Thank you.
Okay, time is fast spent, but there is one question for Professor Tuguba. And unfortunately, after his response, we will have to bring the proceedings to an end. I see a hand up from Mr. Broby, but what we are going to do, because time is fast spent, we'll take all the written questions and we'll send them to the panelists, and they can provide written responses. So the final question to Professor Tuguba is as follows. It says, Professor Tuguba used language pristine customary law to distinguish customary law before colonial or non-African contacts. In this regard, he does not take into account intra-African community contacts, which no doubt modified law in separate customary African countries. Isn't tracing pristine customary law almost fictional? I think it's more of a comment than a question, but I don't know if Professor Tuguba has a response, and then we will end our presentations. Mr. Broby, hang on a minute, please.
So what you are referring to, what the questioner is referring to is what we call internal conflict of laws within Africa, a phenomenon that is not as well known as the more popular concept of private international law or conflict of laws generally. And what I've just said is symptomatic of the problem with customary law. Many of us don't know what customary law is and how customary law used to be. All we know is what Rattray wrote about what customary law was, according to what he perceived it to be. So we have to be very, very careful. I'll end with just one example. It is not true that customary law was not recorded. Customary law was more effectively recorded than in writing. In some communities in Southern Africa, the way in which somebody wrote their will was in the spatial arrangement of the homestead. The way you arrange your homestead shows who is going to succeed you, who is going to take this cattle, who is going to take. What is more effective than that form of recording? Is that no more effective than a will that can be changed and forged by court officials? So there are so many misconceptions about customary law. And before we make certain value judgments, let us do some deeper learning about what customary law really was. I learned customary law from my dad, sitting with him for hours and asking him, why does this foolish thing in customary law happen? And then he tells me that is not the customary law. The real customary law is X, Y, Z. And then it made perfect sense because what I was recounting to him was the distorted customary law. Let us be careful. Thank you.
Thank you very much, Prof. That is a very good note on which to end the panel presentations for today. I'd like to thank all the presenters, speakers, participants on behalf of the Center for African Legal Studies at the UPSC Law School and the Lightness Center for International Law and Justice at the Fordham Law School. At this point, let me say that it's unfortunate we couldn't answer all the questions. And there are about 14 or 15 questions, and there were a few persons who had their hands up. So this would have gone on and on. But I think the debate should not end. So we should continue in our own faculties and write papers. At this point, I will hand over the proceedings to the Emcee, Mr. John Mensah. Mr. Mensah, over to you.
Thank you, Prof. Kwao, for that wonderful start to the relay. In a few minutes, we will be heading over to our second panel, which also promises to be very interesting. I would like to introduce one of my very own mentors from the Lightness Center and somebody I have worked with on corporate social responsibility issues as well as human rights, etc. Professor Paolo Galizzi. He would take us through a chat with the Supreme Court, a discussion on the Supreme Court, the African Customary Law, and then the chieftaincy system. Professor Galizzi is a professor for sustainable development and legal initiatives at Fordham Law School. Prof, if you're with us.
I'm here. I hope everybody can hear me properly, loud and clear.
Yes, Prof. Good morning, Prof.
Good morning, everyone, and thank you so much for the conversation. There's a little bit of a surprise in the sense that both our panelists are not able to join us. Justice Broadbent, unfortunately, just let us know that he wasn't feeling well, and therefore we're going to try to postpone the panel to tomorrow. We're going to see if we can squeeze it in. And Chief Justice Mutunga is in a meeting at the Open Society, and the meeting hasn't finished. The good news, though, is that we ran over a little bit with the previous panel because we were having an interesting conversation. So if the other panelists are with us, what I would suggest we do there were many, many questions that we received from participants. What I think we can do, we can maybe take some of the questions, and then we will try to reschedule the panel on the Constitutional and Supreme Courts and how they dealt with customary law. Would that make sense? If the panelists are here, what I can do, I can ask some of the questions that have been put in the chat. I'm going to start with a question from Linda Ozaje that says, this question goes to Dr. Regosa and Dr. Newman. And the question is, will OBAS chiefs or emirs compulsorily apply customary law in their community as a way to further deepen the involvement of the people and upholding the customs of the people of Nigeria? And the second question to you both is, can a person who is before custom arbitration be made to opt from oath taking as it is applied in the common law court where a witness is made? Dr. Regosa and Dr. Newman, if you're with us. Thank you.
I'm sorry, Prof. I didn't quite get the questions clearly.
Okay, let me repeat it for you. Sorry. The first question is, will OBAS chiefs or emirs compulsory apply customary law in their community as a way to further deepen the involvement of the people and upholding the customs of the people in Nigeria? And the second question is, can a person who is before customary arbitration be made to opt from oath taking as it is applied in the common law court where a witness is made to affirm?
Thank you, Prof.
You're welcome.
I will start with the second question. That is actually our argument that oath taking is not an African thing. Africa has its own form of oath taking, but in English law, there are also forms of oath taking. So we are saying that there should be a way to incorporate the African style of oath taking in our laws in Nigeria. Instead of perceiving it as just barbaric, there should be ways to improve it because of its importance. Over time, it has proven to be a useful dispute resolution mechanism. We are not unmindful of the shortcomings, like could be manipulated. However, even the English style of dispute resolution is also susceptible to manipulation. So it is an improvement. And this will take me into the second question. If we encourage customary arbitration and indigenous ways of dispute resolution, it will further help to preserve the cultures of those communities. And as we know, one of the characteristics of customary law is flexibility, and it is dynamic, it evolves. If we are allowed customary law to keep evolving without the interjection of colonialism and English law, perhaps by now it should be something that is appealing to even the Western world. Thank you.
Thank you. There's another question for Professor Himonga. And let me see, the question is it not the case customary law had to go through the repugnant test because of the many tribes in many African states with varied and many customs? How can Africa develop its own criteria to distill the many customary laws in the continent? I think it's time something was done. Professor Himonga, what are your thoughts on this question, please? Or any other of the panelists or any of our current and future speakers that want to chip in. Professor Himonga, go ahead, please. Thank you.
Yes, my thoughts are that that's a very reflective question and something that we really are trying to work on as researchers in customary law. The question of how do you actually sift those aspects of customary law that need to be developed in order to bring them in line with the requirements of human rights, for example, in the sense that we know human rights. I think that one of the speakers mentioned, customary law has got its own values as well. And so what we should really be looking at are what are the values that could inform the morality that, that is on the African continent as opposed to the morality that is derived from other places. We have values, for example, embodied in the concepts of Ubuntu. We have, values that are embedded in concepts of justice in the sense of what is justice in the African understanding. So what we should be looking at is the Repugnancy Clause itself was problematic because of where it drew its morality, where it drew its equity, where it drew its ideas of what is just. And I think that on the African continent, we do have ideas of justice. We do have ideas of morality that we should be looking at. I just give an example of, the concept of Ubuntu that was, well articulated in the decision in the South African decision of S against Makwanyane, and was used extensively by the judges, by the way, to abolish the death sentence. And so my response to the questioner is, there are values on the African continent that we could use to actually sift those ideas that are not acceptable as notions of justice as we understand them on the continent. That would be, and that's the challenge of research, by the way. That's where scholars must be directing their attention, is actually to dig into what are the values, as opposed to what are the rules of customary law. Values underlie rules of customary law, and this is what we need to understand in order to be able to apply this system of law within the African context of thinking about what is just and what is Ubuntu, what are the values that inform these rules of customary law.
Thank you, Professor Himonga. Thank you very much. I have one more question for Dr. Newman, and then we can move on to the second panel. Dr. Newman, the question is it not possible that customary law by oath-taking may be subject to malpractice? I have witnessed in Nigeria a situation where the wealthy party bribed the juju priest administering the oath in a theft dispute to skew it in its favor against the other party. So how do you deal with potential malpractice in customary law oath-taking? Dr. Newman.
Thank you, Prof. Obviously, like any other dispute resolution process, is susceptible to manipulations, no doubt. But our argument is that even the English style of dispute resolution or resolution by the Western, dispute resolution mechanism by the Western world, is also susceptible to malpractice. For instance, in Nigeria, there are cases of bribery of judges and so on. So we are aware that there are cases where customary arbitrators may have been influenced or induced. But however, there are mechanisms to check that. And one of the mechanisms to check it is that unlike the arbitration, the commercial arbitration we know of, which is private, customer arbitration is public, so everybody is there. And the enforcement of the award from customary arbitration, it is the community as a whole that enforces it. And from their observation, they can detect manipulation. Thank you, Prof. I hope that answers your question.
Thank you. Thank you so much, Dr. Newman. And thank you so much again to all the panelists, and my apologies for the inconvenience. Both Chief Justice Mutunga, and Justice Broby apologize. We're going to try to reschedule it for tomorrow if we can squeeze it in tomorrow's panels. Otherwise, we'll set up an additional conversation. It seems to me that there clearly is an interest in African customary law, and the more interest there is, the more events we can set up. And I think my job is done, even though I didn't perform the duties that I was supposed to. Let me pass the torch, so to say, to John Mensah, that will introduce the next panel.
Thank you very much, Professor Galixi. But before you go, I'd like to ask you a question. You have been working all over the African continent for over 20 years. Now, my question to you is, I mean, you have been doing a lot of human rights work on the continent. My question to you is, when there's an intersection between the human rights and then customary law, what are the relevant challenges that sort of are very very visible in trying to implement new human rights policies where customary law is the only law that the people know?
You're asking a very interesting question. Fortunately, there are many, many more panels coming where all of these issues will be addressed, and I don't want to take on more time. Let me just say two things, because I've noticed in the comments, we apologize if we haven't answered all the questions that you posed, and if we're not answering or relaying all your comments. It's not because we disagree or agree with you. It simply is that there is no time to ask all the questions or relay all the comments. So it purely is a question of time, not a statement on whether we agree or disagree. And again, what I said earlier on is that we clearly see that there's an interest in this topic, and we will do more. So please keep the comments coming, stay in touch with us so that we can organize many, many more conferences on African customary law. My personal view is that all legal systems, including African customary legal system, struggle with the consistencies and inconsistencies, not just African customary law, but you can look at our own legal system in the United States and its inconsistency and its struggle with human rights and modern tensions. And I think those are issues that exist everywhere. But I think the presentations that we've seen today from our great panelists, I really enjoyed all of them, are giving us insights and ideas on how to reconcile. At the end of the day, the legal system is really a tool to solve situations that present themselves. And the question is, what is the most appropriate legal tool to solve a particular issue? Is it traditional African customary law? Is it human rights law, domestic or international? Is the constitutional legal system? But we will get these and more answers in the next panel. So thank you very much, and apologies for the change of plan that was due to unforeseen circumstances.
Thank you very much, Professor Galixi. So we move on to the second panel of the day. This panel is on family law, gender, and African customary law. This panel will be moderated by our very own Dr. Francisca Appiah-Kubi from the University of Professional Studies, UPSA Accra. Dr. Francisca. You're on mute, Doc.
Hello, Mr.
Doc, I can hear you. There seem to be some slight challenges with the network, but hopefully Doc would come through.
Mr. Mensah. All right, good.
Yes, Doc.
Good afternoon. Can you hear me now?
Yes, we can hear you.
All right. I'll turn off the video. I think it's interactive. Fine. Okay, so good afternoon and a warm welcome to the second panel for the African Customary Law under the theme, Family Law, Gender and African Customary Law. To help us with this discussion, we have a list of esteemed speakers who have distinguished themselves in their areas of research. And the first on my list is Dr. Maria Rita Bartolomea, who would be talking on law, custom, and gender in Tanzania and Zambia. She will be focusing more on the advocacy work carried out by Women Lawyers Association to empower women's rights and status. Our second speaker is Dr. Fructus Bijirimana, and he would also be focusing on the discrepancies between gender equality promotion and customary law in Rwanda. He would also touch on the statutory changes made in Rwanda to ensure to promote gender equality. Our third speaker, Professor Angelica Bonfanti, would be speaking on customary family law and traditional practices, striking the balance between cultural diversity and fundamental human rights, questioning how African countries intend to carry out their international obligations, considering the cultural diversity that exists. The last speaker, but not the least, Mr. Joseph Bafwe-Diamwa, would be covering survival of customary law in a changing African society. He would also be placing serious questions on how the customary law will has been surviving despite the dynamic modernization of our society. So without wasting so much time, our first speaker, Dr. Maria Rita Bartolomea, is a lawyer, independent researcher of legal and cultural anthropology. Dr. Bartolomea, the floor is yours. You have 12 minutes to make your presentation, and to our wonderful audience, kindly take note of all your questions, or you can post them in the Q&A icon down there, so that at the end of all the 4 presenters, you would be given the opportunity, or your question will be raised for them to answer. Dr. Bartolomea, the floor is yours.
Thank you very much, Francisca, and good afternoon to you all. My contribution to this panel focuses on the current role of customary law in Tanzania, both in challenging the state law and in delaying women's empowerment and emancipation. Customary law, in fact, is rooted in kinship relationship and values, and is particularly concerned with marriage, divorce, child custody, control of family property, and inheritance. As we all know, scientific discussion about the definition of customary law is still lively and rich. I think, however, that the African concept of customary law is rather problematic and different from both Western and international one. In talking about these issues, the perspective of legal pluralism can be useful. At the same time, an anthropological approach can help to understand the cultural reasons why law is ineffective or biased according to Western human rights standards. In relation to this, I would like to report some results of field work carried out both in Tanzania and Zambia with local women's lawyer associations, the Tanzania Women Lawyers Association and the Women and Law in Southern Africa, Zambia. These are 2 NGOs which fight strenuously and successfully against discrimination, inequality, gender violence. I don't have the time to explain my entire project, so I will limit myself to offering some reflection on the legal, social, and political problem of gender inequalities in access to land. In Tanzania, the land has always been the primary source of wealth and livelihoods. Besides, the land is not only a geographic and economic space, but also a cultural, spiritual, and social space. 3 parallel systems of interstate succession operate: customary law, Islamic law, and the Indian Succession Act. While both customary and Islamic law are discriminatory, the Indian Succession Act is gender neutral. In practice, however, it is rarely applied where customary law is widespread. Unfortunately, customary law often denies widows their inheritance and limits daughters. Although the 1997 Constitution, the Land Act, and the Village Land Act introduced in 1999, as well as all the other more recent legislative provisions sanction the principle of equality in the allocation of land resources, in practice, women cannot access them, especially in rural and more remote areas of the country. Here, archaic social arrangements persist. Each family, for example, prefers to assign land to sons, future head of the family, rather than to daughters, because they will marry and leave home. Often the girls are forced to marry precisely to prevent the family property from being lost, but marital status does not guarantee possession of the land. Married women can receive part of the family land, but only use for the purpose of the cultivation of subsistence products, and provided that they respect the limits imposed by parents and other relatives of her husband. Polygamy fuels discussion and conflicts over the distribution of resources, even more so after the death of a woman husband. Normally, relatives of the deceased or other members of the village take away all the husband's assets from widows, including parcel of land. In the past, women have never contested this type of social organization, also because the strong bonds of cooperation and solidarity prevented them from being in a situation of serious need. Current economic modernization instead, and the intensive exploitation of land, including by foreign investors, has led to the progressive replacement of crops for domestic or commercial use with big plantation or monocultures, managed and exploited by men. What is more, in the transition to modernization, men took advantage of the breaking of traditional ties and the loss of authority of the elderly to discriminate against and exploit the poorest and weakest sections of the female population. This mainly depends on the arbitrary application of various unwritten rules of customary law, as well as on a patriarchal drift or male domination. We witness also a sort of local resistance to the ongoing globalization of Western principles, values, and legal standards. Since the chiefs who dispense such law and settle disputes at the community level are always older and wealthier men, they tend to strengthen prevailing hierarchies rooted in old sociocultural and juridical structures. We should also add that many women are uneducated or even illiterate and have no financial resources to access state justice. Other bad situations are the same lack of a clear legal awareness about one's rights, fear of retaliation, bureaucratic delays, and the lack of trust in public officials. To dismantle these inveterate systems of oppression and exploitation and to accelerate women's empowerment, the jurists associated with TAVLA coordinate the activities of the Gender Land Task Force. It is a political coalition which struggles to effectively change the inheritance system and family law. Through a set of suitable legal instruments and tools, they are fighting to provide greater legal guarantees to women and the protection of human rights for all. For example, they offer free legal aid to the poorest women and undertake continuous national campaigns to raise public awareness and promote women's rights and action. Finally, individual experiences, narratives, and viewpoints gathered in the field clearly show just how women often experience discrimination twice, both inside and outside the courtroom. But in their attempts to spread awareness of legal rights among women and children, they transform themselves, their working space, and the wider society of which they are part. In conclusion, their activism show how the law often fails to protect women, and also how the empowerment of women through the law is still a long way from achieving freedom, dignity, and social justice. Thank you very much for your attention.
Thank you so much, Dr. Bartolomea. You were very efficient with your time, I must say.
It was very short, very quick.
With that, we move to our second speaker, Dr. Fructuous Bigirimana, who is the former Dean, Faculty of Law, Institute of Applied Sciences, Rwanda, and he'll be speaking on discrepancies between gender equality promotion and customary law in Rwanda. Dr. Bigirimana, the floor is yours. Hello, Doc. Okay. It looks like we're having some small challenge with Dr. Bigirimana. So with that, we would move to our next speaker, Professor Angelica Bonfatti, who is the head of the Master's Program in Sustainable Development, Law Faculty, University of Milan, Italy. She will be speaking on customary family. Oh, well, we have Dr. Fructuous Bigirimana joining us. Dr. Fructuous Bigirimana. Welcome. Okay, yes. The floor is yours. You have 12 minutes within which to make your presentation.
Hello? Hello?
Hello? Is that Dr. Bigirimana? Hello?
Yeah.
Is that Dr. Bigirimana?
Yes, I'm there.
Okay, kindly proceed. Okay, kindly proceed.
Yeah, thank you very much. Thank you very much. As you say, I'm Dr. Bigirimana Fructuous. I'm the former Dean of the Faculty of Law in Pristine in Rwanda. Yeah, it is a pleasure to me to be with others, especially those eminent experts in international law in different domains, in international law, customary law, especially. My little contribution is about discrepancies between gender equality and promotion of gender in customary law in Rwanda. So the promotion of gender equality requires formation of policies and laws that recognize the law of gender equality. In this regard, the government of Rwanda has adopted measures and different policies and laws in favor of gender equality. However, the customary law still predominant in the day-to-day life of Rwandans. And this customary law is recognized by the Rwandan Constitution. And in Article 201, paragraph 3, recognize customary law, but only if it is not inconsistent with the Constitution and if it does not violate, if it does not cause prejudice to public order. And in this regard, I'm going to see how this recognition of customary law leaves some little rooms for customary practice which are contrary to, are in contradiction with fundamental rights. However, the deep rooted traditional practical stereotypes regarding the role of and responsibility of men and women still persist in the country, in Rwanda. So my presentation now, I'm going to try to review the progress made in Rwanda and highlight the barriers encountered by registrar through I'm going to present through 5 pillars of life in Rwanda, namely the household decision making, how women and men in their household would take decisions because it's the life of day to day. And the second pillar is land acquisition, because 80% of Rwandans lives by the agriculture, by farming. So I'm going to present how the acquisition of land is based on the customary law, and this customary law is somehow in contradiction with the fundamental right, human rights, or even the Rwandan law that has been adopted. Then the third point will be the control of economy. The control of economy in the house. Who decide how to use money? Who decide how to use money earning by women, or how to use money earning by men? So also, and the fourth point will be the implication of women in decision making, political decision making. So those will be the four points of the pillar. Participation in household. This is the law recognized. I think I can use the share this if you want. Let me.
So we seem to be experiencing some unfortunate Wi-Fi or internet
to share the
issues.
Okay. Let me continue with yes. I think it's here.
We can later share your slides, so you can continue.
Okay. Yeah, it does not matter. So let me continue. Yes. Yeah. Let me continue with the presentation by yes, about the participation in household decision making. The law in Rwanda recognizes equality of men and women in the family, but in contrast, according to Rwandan customary law, all family decisions are made by the chief of the family, and the chief of the family in Rwanda is the man. And this is the practice in the whole country. The ability of women to make a decision that affects their personal life, their personal processes, is essential for their development, for their empowerment. But to assess this, women decision-making autonomy, there was a study conducted in Rwanda in 2014-2015, and the survey collected the information on Madi women's participation in the 3 types of decision: their own health care, they measured the decision about household purchase, and the decision related to the visit of the relatives of the family or friends. About healthcare decision, women are considered to participate in decision-making if they make a decision alone or jointly with their husband. And the study has shown that 30% of women participate in making a decision about their own health care. Those among them, 23 of them decide solely about their own health care. On the other hand, 60% of the women have not to say on their own healthcare decision. And this is very dangerous. If a man take a decision in the place of the woman about her own life, and this is very dangerous. The decision is taken by his husband. And this practice of the customary law is totally different from the law, the quality of women and men taking decision, but also it affects human right in terms of right to life. When you take a decision of your wife, it is aberrant. It's not. So about the decision to purchase, to take what to buy, how to use money, how to spend money in the household, the madmen are also more likely than women to be involved in a decision regarding household purchase, because 73% respectively and slightly over 1/4 of women say that decisions are usually made by the husband alone. That means that the decisions of taking decision what to purchase, how to use money in purchasing, the decision 26% decisions are made alone by husband alone. The woman has no decision, nothing to say about it. About the visit, 17% of women decide themselves on the visit of their family. 17%, the visit of their family, they decide, or friends or relatives, while over 68, they decide, the decision is taken by the husband. And this shows that there is a contradiction, or there is a contradiction between equality, gender equality between the men and the women in the house. If the law promotes the equality, here we see in decision making in the household, the customary law still prevail, and the customary law is applied instead of applying the law. Let me talk about the control over women's cash earning. The control over cash earnings, I'm going to divide into three parties. Control over cash earning by women, and the control over cash earning by his husband. So this will help us to assess the autonomy of married women who earn cash for their work, and how, in which extent they have right to use it. The study above mentioned, a survey conducted in 2014-2015, 18% of men report that they mainly decide how their cash earning are used. Is the cash earned by women. And 78% that they make the decision without consulting their wife. And only 2% state that the decision are made mainly, yes, sorry?
You should be rounding up.
Yes, I'm saying that only 2% state that the decision are made mainly by their jointly with their man. So this shows that even women earn money, they cannot decide how to use. They cannot decide the way they will use the money they earn themselves. And this is also in contradiction with the Constitution, in the Constitution in Rwanda, the Constitution which provide that they use the right to property. Once you earn your property, you have the right. And this is also a source of empowerment of women in the economic life in the country. Let me go to the third point about the women land acquisition and succession. And this because 80% of the population of Rwanda work in agriculture and livestock farming. The vast majority is made up of subsistence farmers who depend on the land for survival. So, due to the population growth and inheritance practice, require family land to be divided among all male members. Each new generation land holding it's the land, once land is acquired, is given to the male, to the son, without considering the women. In Rwanda, land ownership was or is by customary law, regulated by customary law, and which the land is belonging to the or was belonging to the man. However,
thank you.
The Rwandan government has adopted a set of laws and policies to deal with those land-related problems, especially land distribution between male and female in the family. In this regard, the adoption of the new law, the law of 1999, on regimes, penalties, and successions, and the gradual dissemination of the information on land rights, the new law has addressed this problem and influenced the customary law. And this law has introduced 3 major changes. It granted daughters the right to inherit land from their parents. It gave wives the right to matrimonial property. That means that the property has to be divided between the daughter and the male, and between the male and the female. And the third point, the change of the law allows the widow to inherit the husband property. And this is a good change in relation to the access to land by the women. Dear participants, dear panelists, I want to end by participation.
Okay, thank you so much, Dr. Fructus, for throwing more light on the challenges faced in Rwanda, particularly connected to land acquisition, control of economy, political decision-making, and household decision-makings when you contrast the roles of men against women. Thank you very much, although we're having some small technical challenges. We would now move to our third speaker, Professor Angelica Bonfatti, who is the head of the Master's Program in Sustainable Development, Law Faculty, University of Milan, Italy. Should be presented on the topic customary family law.
I cannot hear you properly. Now, yes.
Yes, Professor, you can go ahead.
Okay, thank you very much. Can you please confirm that you see my presentation?
Yes, it's visible.
Thank you. So let me first of all thank the organizers for convening such an interesting conference and giving me the opportunity to participate. My presentation, as you can see, will aims to assess the compatibility with international law of some African family customary laws and traditional practices, either potentially inconsistent with the prohibition to discriminate against women. For instance, those practices pursuant to which wives lack contractual capacity and standing in law, or those practices under which women are disqualified from being able to own land and from inheriting. And also to assess the compatibility with international law of those other practices that amount clearly to serious violations of human rights, such as the female genital mutilations and forced and child marriages. From the beginning, we have seen that customary law and customary practices have many positive impacts and very positive role, but my presentation will focus on those practices that are still to be still potentially or clearly incompatible with human rights. These practices, from my perspective, that is the international law perspective, in fact, give rise to complex legal issues, complex legal questions, such as whether they should be considered unlawful or disapplied, and even and to what extent states are allowed to exercise their margin of appreciation when dealing with them. My presentation will basically start with a very brief recall of the theoretical debate, and then go into the main problem it seeks to assess. Starting from the theoretical debate, the compatibility of traditional practices and customary law with international human rights law clearly makes me referring to the universalistic conception of human rights on the one hand, and cultural relativism on the other end. There is obviously no time to get into this. Sorry?
Please go ahead.
Okay. There is obviously not time to go into details about universalism and cultural relativism. I can only remind that both theories have been criticized. The first one, the universalism of human rights, has been criticized by anthropologists, for instance, and considered to lead to such a westernization of human rights that would disregard the local traditions, while culturalism has been criticized for the negative attitude towards change. Now, my position, to make a long story short, is that nowadays cultural traditions and customary laws are not only acceptable if seen from the international law perspective, but also protected at the international law level. I'm referring to the so-called phenomenon culturalization of human rights. On the other hand, and despite this specific protection of cultural diversity at the international law level, there are still some very fundamental human rights that cannot be derogated from because of their universally mandatory status. Now, few words on culturalization of human rights. What is culturalization of human rights? Basically, it is the phenomenon according to which cultural diversity and cultural rights are protected at the international law level. Here you can see a selection of the main international law provisions that protect cultural diversity. For instance, the UNESCO Declaration of Cultural Diversity clearly states that the defense of cultural diversity is an ethical imperative inseparable from respect for human dignity. But also the international covenants on economic, social and cultural rights, or international covenants on civil and political rights, or the conventions on the protection of indigenous people's rights, are all in the direction of protecting cultural diversity. And then all the rights established at international law level must be interpreted in the light of cultural diversity. For instance, the right to food is correctly implemented by states only if they provide culturally acceptable food. That means that the right to food must be read in light of cultural diversity. There is another interesting phenomenon to be taken into consideration when dealing with the relationship existing between customary law on the one hand and the protection of human rights at the international level on the other hand. And this phenomenon attains to the influence by local traditions and local culture on the system of protection of human rights at the regional level. For instance, if we take the African Charter of Human and People's Rights into consideration, we can see that the Charter is strongly influenced by the African culture, insofar as, for instance, it provides for a collective dimension of human rights. Or if we see that the Charter does not distinguish between the three generations of human rights. And these are peculiarities of the African Charter of Human and People's Rights that differentiate the African system of protection of human rights from the United Nations one. Nonetheless, the fundamental human rights established by the two systems are pretty much comparable. Now, having said this, I must add that even though the legitimacy of the international human rights regime is very linked to such a culturally sensitive approach I have tried to describe. There are still boundaries, there are still limits that culturalization must, limits to be posed to culturalization of human rights. What do I mean? That all the international legal instruments that I have mentioned before and that recognize cultural diversity and protect it, at the same time explicitly establish that cultural diversity cannot be cannot infringe upon human rights. So the international legal instruments providing for the protection of human rights recognize cultural diversity, but at the same time explicitly clarify that cultural diversity must be applied within the limits of the international human rights. And obviously there is also a general limit that cultural diversity can never derogate from. This limit is jus cogens, which means that those few principles recognized at the having the status of jus cogens can never be derogated from through the implementation of cultural diversity. So going to the family practices, my presentation takes into consideration. So if we, for instance, take the most serious, the practices involving, for instance, family genital mutilations or forced child marriages into consideration, I would say that these practices are clearly inconsistent with international law, insofar as they are inconsistent with the fundamental rights established by jus cogens, the right to life, for instance, and the right to be free from enslavement. This has been recognized not only by the International Criminal Court when dealing with the forced marriages in Uganda and Sierra Leone, for instance, recognized as amounting to crimes against humanity by the International Criminal Court, but also by the Court of Justice of ECOWAS, for instance, in a very interesting case concerning the claim filed by a Nigerian woman, a woman from Niger, who complained of having been sold when she was 12 years old by the leader of the tribe to a man aged 46 within the context of a traditional practice applied in Niger, the so-called wahiya, I don't know whether the pronunciation is correct, and the ECOWAS court concluded that this practice is this practice is contrary to international law, and that the state, Niger, was responsible because it had not prevented the implementation of this practice. Then, coming to the other practices, traditional practices I have mentioned before, they can be potentially inconsistent with the prohibition to discriminate against women. That prohibition is recognized and established at international law level, for instance, by the Convention for the Elimination of Discrimination Against Women or the Convention on the Rights of Child, but which these conventions explicitly take the role of traditional practices into consideration. both the CEDAW and the CRC, in fact, established that the state parties shall take all the appropriate measures to abolish the traditional practices prejudicial to women and children. The same approach is incorporated within the African instruments, the African Charter of the Rights and Welfare of the Child and the Protocol on the Rights of Women in Africa, that both provide for the obligation of states to abolish the traditional practices inconsistent with the prohibition to discriminate against women and the protection of children. Now, if the reading of these legal instruments might let us conclude that there is a prohibition, a general prohibition to discriminate against women at the level of international law, I must also add that this prohibition has not acquired the status of customary international law. In fact, I cannot abstain from reminding that many Islamic states, among them also some African states, have made reservations to both the CEDAW and the CRC conventions, limiting their application within the condition that they are consistent with Islamic law. And Islamic law is not necessarily compliant with such a prohibition to discriminate women. Thus, I go to the conclusion of my presentation. Notwithstanding this lack of customary international status of the prohibition, there is a very interesting case law developed by the African courts for the protection of human rights, and specifically by the first case I would like to mention was solved in 2018 by the African Court of Human Rights. The case, the decision of the African Court was in the direction of considering Mali responsible for the violation of the prohibition to discriminate against women because of the provisions of its family code, under which the local traditions and the customary law could be applied, and the local and customary law did allow for discriminatory treatment of women regarding the right to inherit and the right to marry. So the conclusion of the court was that Mali had to amend the legislation as to make it compliant with the prohibition to discriminate against women. The other two cases I have mentioned instead concern the responsibility of Sierra Leone and possibly in the future Tanzania for the policies, the governmental policies according to which pregnant girls are banned from, are precluded, prohibited to attend schools. The case against Sierra Leone was decided in 2019 and concluded that Sierra Leone was responsible for the violation of the prohibition, while the court against Tanzania is still pending. So just the few words. It seems to me that I have mentioned these cases because it seems to me that even though there are clearly still practices, there are in place still practices inconsistent with human rights, and that might be challenges for these inconsistencies. These cases show a very interesting approach at the African level and possibly a very interesting evolution in this direction. Thank you very much.
Thank you very much, Professor Bonfatti, for a detailed presentation. Now we'll move on to our last speaker, in the person of Mr. Bafo Edriamwa. He's a lawyer by profession and a lecturer at the UPSA Law School. His presentation will be on the survival of customary law, well, in a changing Africa. Mr. Edriamwa, the floor is yours.
Thank you, Prof. And thank you again. I'm very happy to be with you, and I'm happy to do a presentation in this prestigious conference. My name, as mentioned, Bafo Edriamwa, simply called Joe Bafo. I'm a faculty member of UPSA Law School, that's the host institution for this conference. I've carried out an empirical research into how oral will or customary law will, that is oral testamentary disposition, is carried out in some of our communities here in Ghana. And I will be very happy to make a presentation on that. To begin with, to give a general overview of customary law wills, I will say there is a general proposition that every man of full age who is able to speak and of sound mind is capable of making a testamentary disposition as customary law in any African community. Customary law will, known as Samansew among the Akan people of Ghana, just refer to the oral testamentary disposition that is made in accordance with the relevant customary law. And if you look at it closely, it is very similar to the English common law concept of donatio mortis causa. That is a gift of personal property made in anticipation of a donor's imminent death and intended to be effective. The gift is intended to be effective after the donor's or the testator's death. This is a very ancient practice, but has survived the evolution of customary law throughout the ages, and it is still being extensively practiced in a considerable number of communities. So I went on the ground to do a research to find out in some communities in Ghana whether the practice is still prevalent and maybe get some reasons why it has this practice has survived in such a fast-changing African society. So,
Mr. Edriamwa.
Hello.
Could you kindly move your mic a bit closer to your mouth so that we can hear clearly? Yes, thank you.
Can you hear me now?
Yes, please.
Thank you very much. Let me see. Oh, is it better? Is it better from here?
Yes, please proceed.
Thank you very much. So, what gave me this interest was that sometime in 2019, I attended a funeral in a small community called Aveme in the North-Dai district of the Volta region in Ghana. And I witnessed a kind of cultural practice, which this custom attracted my curiosity and decided to get closer to find out what was actually going on, and then maybe ask some questions. But you know, the language barrier could not allow me to get more understanding. So I decided at a later time to get a native of the community who could do an interpretation of what I had witnessed. From a distance, my initial conclusion was that they were trying to prove the existence of a customary law will. A customary law will. That is how I concluded, but it was not exactly so. And so when this conference came up, and in tune with the theme of this conference, that is customary law in a changing Africa, I decided that this is an opportunity to undertake a research into this age-long practice of oral testamentary disposition of personally acquired property in accordance with customary law and practices in some communities. So my mission was simple: go on the ground, find out how it is executed, find out how extensively it is being practiced, and then find out why people believe in this customary law making of wills as against statutory wills. So how did I do this? I went to 3 communities. I selected 2 patrilineal communities in Ghana and then 1 matrilineal community to undertake this research. So, like I said, my first instinct was to go back to Aveme, where I had earlier on in an earlier visit witnessed something which I thought was a testamentary disposition. This time around, I got somebody, a native, to accompany me back to the community, who arranged a couple of interviews for me. And one of the most, what do we call it? One of the best of the interviews that I had was with a very prominent chief of the community. But before I go into that, I would like to just give a brief summary of how testamentary disposition of customary law is carried out in Ghana, especially, so that with that one behind us, people may appreciate why I was putting certain questions and then why I was seeking certain answers. Disposition under customary law, also known as customary law will, like I stated earlier on, it is simply a practice where any individual who is of full age, who is able to speak, who is of sound mind, these are 3 qualities, will make an oral testamentary disposition of personally acquired property before death. Well, it has sometimes been described as deathbed disposition or non-cooperative will, which in essence is an oral statement directing how one's property should be distributed after one's death. It is only, we should note that it is only directed in respect of personally acquired property during the testator's lifetime. And although it has been described as deathbed disposition, meaning it is made in anticipation of the donor's imminent death, it is not always the case. It could also be made during the testator's perfect state of health. A very essential requirement of customary testamentary disposition is publicity. That is to say that at the time that the testator is making the statements, there must be witnesses. And the witnesses must be distinctively told by the testator that the words are his customary law will, to take effect after his death, so as to serve as evidence of a testamentary intent. However, no particular form of words is necessary for the making of this will. Another essential requirement is that the witnesses shall be persons who could we could describe as people who are responsible, credible, or disinterested witnesses. Among the Akan people of Ghana, the general practice is to invite members of your family and then make your statements in their presence. And here, when I say members of your family, I am referring to what we call the extended family. Even if you invite your immediate family, that's your children, they are observers. It is also a requirement that if you can get hold of your head of family, which is known as the Abusuapenyi in Akan, he is the one who is supposed to be the prime witness. Because in Akan, after a man's death, it is the Abusuapenyi who directs as to who gets what. Now, having given this background, I went to Aveme, and my first interview with Togbedra IV, who was described as the chief priest of the Aveme community. To start with, I asked him for how long he has been the chief, or he has occupied the stool. He said he was installed as chief, he was installed as the chief in 1984. That is to say, he has occupied the throne for 36 good years. And my first question to him was whether the customary practice of making an oral testamentary disposition in accordance with customary law and practice do exist in his community or do apply. His answer was emphatic yes. I then asked a second question, as to how prevalent the practice is. And his answer to me was simply, it is as prevalent as there is death at any time, because according to him, no funeral rites of a deceased person from the community will end without a question as to whether the deceased left behind some instructions in relation to his personally acquired property being asked. He said at the end of every man's funeral, or every woman's funeral, or every individual's funeral, the head of family has an obligation to demand whether during the lifetime of the deceased man or woman, he left such an instruction. This they refer to as a customary law way. Then I asked the chief, Togbe Dra, the fourth, an open question that Togbe, assuming you as an individual, on this very day, you decide to make a customary law will, how will you go about it? For the sake of time, I will just give a brief summary, and I will want to say that what he told me was not so different from what we know from the Akan communities. It is about assembling eminent or prominent or principal elders of your family, including the head of family. And if your children are available, inviting them and then making your wishes known to them. After all the statements from the testator, according to Togbe, head of family is supposed to ask members assembled whether anybody has anything to say. Thereafter, the next thing is for the head of family to pray over whatever the man has said, and in local parlance we say to pour libation. So I asked a further question as to whether the testator is at liberty to distribute all his personally acquired property, or there is a limitation as to what percentage could be gifted out. Togbe say what is your personally acquired property is for you, and there is no such limitation. I asked this question because Saba had written in his book that there is a limitation, that is infantile land. I don't know if it's still applied, but he made that statement about just disposing up to 50% of your personally acquired property and leaving the rest for your family. also the Achimawapa Traditional Authority enacted a law. Is it 1934?
Please, can you hear me?
Also, hello, also placing a limit, but Togbe says there is no limitation. Now, my main point that I always want to end with all the persons that I interview, including Togbe Dra the Fourth, was this question that throughout the ages, I asked Togbe, you have been the chief for 36 years. Throughout these 36 years, has it ever come to your notice that a man's oral will has been proved after his death, and a dispute has arisen to such an extent that it could not be resolved, and it has gone all the way to the law court? He said, not that he could remember. In fact, on this particular question, he turned to the elders who were with him to ask them whether anybody could remember any such incident, and they said no. That was very informing. And then finally, I asked Togbe whether, in his opinion, why he thinks this practice has persisted all these years, and despite the fact that the making of statutory will exists. Well, he gave me so many answers. I will reserve that to the discussion column, and then I will look at it. Then I decided to go to another patrilineal, what do we call it, community, that is to come to Southern Volta. I remembered an old school friend who had been installed a chief in the Aron area of the Southern Volta. So I contacted him. His student is, hello.
Thank you so much for your presentation. We would have to bring it to a close. So kindly sum up so that we can.
Okay, to sum it up, then let me go quickly to the summing up portion. I have always tried to find out why this practice has persisted and has been prevalent in spite of modernity. And some of the answers I got, let me say, number one, is the publicity that is given to an oral will. That is, there are witnesses such that it is difficult for another person to come and disprove. That is one of them. All right. Another point is that the African strongly believe in the existence of life after death. So whoever leaves an instruction that after my death, this is what you are supposed to do, people are not ready to do anything contrary. That is why maybe the accounts even call testamentary disposition at customary law, they call it Samansil. Samansil simply means a ghost instruction. A ghost instruction, which attests to the fact that we believe in the existence of life after death. And then also, most people make these wills with a great oath. They make an oath at the tail end when they make their disposition. And for that matter, there is always the fear among the African that if you go contrary to the oath of a deceased person, something untoward is likely to happen to you. And maybe because of time, I want to end it here. But I remember I think the professor from Kenya saying, why is it that when people make an oath at customary law, they are ready to abide by it, but they go to court, leave the Bible, and then tell lies? Well, I would want to say that we take seriously our customary practices and making of an oath. We take it very serious in our local communities. Time will not allow me to finish, but I think in a nutshell, I want to end it here. Thank you, Madam Moderator.
Thank you very much, Mr. Duamois, for your presentation. Now we've come to the session for questions and answers. To our dear moderator, dear speakers, would have some few questions. I will pose one or two questions to you. And then I would read out some questions from the audience. But before we start, Dr. Bartolomea has sent her apologies. She had to leave due to an emergency. So her apologies. Now let's proceed. Dr. Frutus, I'll start with you. Your presentation covered quite a comparative analysis of the statutory changes made to ensure gender equality. But in your abstract, there was a portion where there was a high increase in the numbers of women, particularly in Parliament, as compared to the men. Could you kindly explain what accounted for the sharp increase in the number of women in Parliament as compared to the men? Now to Professor Angelica Bonfatti. Your presentation confirms the fact that a lot of international covenants or agreements have been signed, all geared towards the protection of human rights. But we have a lot of cultural practices or traditional practices which do not encourage the compliance of these same fundamental human rights. Is it that the answer does not lie in making more laws, but rather probably in education or reorientation? Your views will be sought on that. Mr. Bakwa, you would have an opportunity to give us one or two reasons we are about to complete on the reasons why educated men, no matter how highly they're educated and how modernized they are more than willing to comply with the customary law will rather than the legally drafted wills of the deceased or the dead people in Africa or in Ghana, in your case, as you did present. So once we are done with the answering of these questions, I would move to read the questions from the audience. So Dr. Fructuous, you could start with your answer. Hello, Doc, can you hear me? All right, it seems we are having some challenges, so we'll move to Professor Bonfatti.
I can hear you. I don't know whether...
And respond or express your views on the statements I made.
Would you like me to start?
Yes, please.
Okay. Yes, I agree perfectly with, thank you very much for the remark you have done, and I agree perfectly with it. In fact, as I tried to demonstrate, there is a huge number of rules at international law level in accordance with which theoretically, at least on the paper, such practices should be precluded. But then, as you have correctly noticed, there is a practical issue that starts from education and women empowerment, I would say. And there is an issue with enforcement also. So this is why I found the cases I've mentioned so interesting because they go exactly in the direction of applying the instrument I had mentioned to the specific practices that are still difficult to reconcile with international law at least, and or inconsistent, clearly inconsistent with it. So I would say on the one hand, there is an issue of education, on the other hand, there is an issue of enforcement without losing cultural diversity, but still in the balance between what is cultural diversity and what is completely inconsistent with universally recognized human rights. Thanks.
Sorry, Dr. Bonfat, just a follow-up, Professor Bonfat, just a follow-up. What kind of evaluatory measure would you consider or would you propose to ensure that these international covenants or agreements are implemented? Since you are saying there's an issue to do with implementation.
Yes, I mean, there are still obviously in place evaluating monitoring instruments, both at the international, the UN level and at the African level. Probably, it seems to me that the individual cases can be very interesting as to demonstrate how the specific provision should be implemented practically. On the other hand, I think that strong commitment of states on the education and women empowerment field is needed and should be strongly called for at the UN and at the regional systems level. So a coordination and cooperation about this would be certainly required and welcome.
Thank you very much, Prof.
Thank you very much.
Fructus, can you hear us now? Okay, whilst we wait for him, Mr. Bafo, you could kindly proceed.
Okay, thank you, Professor. Like I said earlier on, one of the findings of my research was that there existed no correlation between one's social status in life and then the choice as to whether to execute an oral will or a statutory will. That was one of the findings. That is to say that the persons who were executing customary law wills cut across social stature. And the answer has, the question has, even very, very well-educated people on the occasion of making oral will will even give instructions as to how their funeral should be performed or where they should be buried. And the members of their family are ready to carry this instruction through. They do not go contrary to that. That is one of the findings of my research, and I am saying that it does not matter. Maybe cost and access, and then we all know about the challenges with the statutory will, that people go to court to challenge the will and say that, what do we call it? I do not believe my father wrote this, or my mother wrote this, or he was forced to sign a document. At the time he was very ill, he couldn't think for himself. But when it comes to the customary law will, people are assured that their instructions that they leave in the presence of members of their family will be carried through. That is a plus, and that's a plus for African customary law. Thank you.
Thank you so much, Mr. Bafo. Now we seem to have comments from our audience, so I'll read. The first comment says about Gasasa. Forgive me if I got it wrong. That's in Rwanda. Gasasa was a good idea after Rwanda genocide, But the problem is that this traditional court was used as an instrument against political opponents, but also on retaliation against a target group of Rwandans who are accused wrongly as genocides. Okay, and the last comment I would also read out is from Intaganda, and it says, the number of women in Rwanda parliament is a great concern, but what is more important for Rwandans is how those women get to the posts in parliament and what they do once they are there as members of parliament. So we are far behind in time, in terms of time. So we would leave it here. We'd like to express our gratitude to our distinguished speakers for the wonderful work done, to the discussion about family, gender, and African customary law. We are very grateful on behalf of the UPSA Law School and the Center for African Studies and the Leitner Center. Thank you so much for taking precious time out of your busy schedules to share with us this important knowledge. And to the audience, thank you so much. Now I hand over to the Master of Ceremony, Mr. John Mensah, and the Director. Thank you.
Thank you very much, Dr. Kusiapia, and thank you so much to the panelists and the presentation so far. We do apologize for the slight issue of connectivity. These are matters out of our hands, and there's very little we can do about it. Now, I'd like to take you to the last part of today's agenda, that is to have closing remarks from our very able director of the Center for African Legal Studies, our very own Benedicta Lassie. Hello, Benny.
Thank you very much, John, and thanks to our distinguished speakers. I think all of us would agree that today's conference has been an insightful one, very engaging and thought-provoking. I'd like to take this opportunity to thank our distinguished speakers and panelists, our moderators, and also our participants who have taken precious time off their busy schedules to join us today. As you are well aware, today is the first day of the conference, and we are back again tomorrow. Same time from 1 p.m. GMT to 4:30. I would also want to thank our distinguished speakers who have joined us, although speaking tomorrow, have joined us to participate in today's sessions. And I'd like to just mention the few I see here on the screen: Professor Muna Ndulo, Honorable Chief Fortune Chirambura, the Vice President of the Pan-African Parliament and President of the Council of Chiefs of Zimbabwe. We also have Professor Anthony C. Diala, and a host of other speakers who would be joining us tomorrow. So from us here in Ghana and from the Leitner Center at the Fordham Law School, we say thank you very much for joining us, and we look forward again to your participation tomorrow. Thank you, and over to you, John.
So sad we have to bring this program to an end, but we look forward to seeing you tomorrow. Thank you, Director, for the nice and kind words. Goodbye from New York. Goodbye from Accra, Ghana. See you tomorrow. Thank you.